it is with the district government pleader to draft it. So I have called for those files myself as well, my lord.
Sufficient time has been awarded. It has been 23 years.
23, then you are not the owner of the property. It's only by adverse possession.
My lord, another aspect is a decree is obtained. No execution for that decree is filed within the time period given for execution under the Limitation Act. After that period, a writ petition is filed. Writ petition merely says an application, if any, is to be considered. It has been considered, my lord, and an endorsement is already on record. Last time also I had placed it, my lord. In my respectful submission, my lord, with the endorsement, he has to pursue an appellate remedy as against that endorsement.
ನಿಮ್ದು ಅವ್ರ ಮೇಲೆ ಏನೇನ್ ಆಕ್ಷನ್ ತಗೊಂಡಿರಿ?
That is what
ಈ
I'm.
ರೀತಿ ಆಗ್ಬಿಟ್ರೆ ಸಿಟಿ ಲ್ಯಾಂಡ್ ಎಲ್ಲ ಅಷ್ಟು
Yes, my lord.
ಎಲ್ಲ
Yes, sir.
ನಿಮ್ಮ ಆಫೀಸರ್ಸ್ ಎಲ್ಲ ಒಂದಾಗಿ
ಹೌದು.
ಅವರು ಇವರು ಒಂದಾಗಿ ಎಲ್ಲ
time
ಪೊಸಿಷನ್ ಗೆ
ಕೊಟ್ಟಿದ್ದೀವಿ.
WS ಹಾಕದಂಗೆ ಎಲ್ಲ ಪಬ್ಲಿಕ್ ಪ್ರಾಪರ್ಟಿ ಹೋಗ್ಬಿಟ್ರೆ ಮುಂದ್ ನಾವೇನ್ ಮಾಡ್ಬೇಕು?
ಅದಕ್ಕೆ my lord, I have escalated it both to the secretariat as well as.
ಅವ್ರು ಏನ್ ಮಾಡಿರಿ ಅಂತ ಹೇಳ್ಬೇಕು.
District
Government AGA submits that the disciplinary action is suggested against the erring officials of the government and the report in that regard would be filed within 2 weeks. First up, on request, a period of 2 weeks finally is granted. First up, call this matter after 2 weeks.
Needful done, my lord. Needful done, my lord.
Needfully stated to have been done. Registry to verify. Yes. Pass over. Next. Kadama, same order.
My lord, some pending compliance, my lords, I'll take care of it today, my lords.
Steps
I'll ensure it happens today, my lords.
within 3 days.
My lords. Much obliged.
Filling which petition stands rejected.
Much obliged.
Two weeks.
Same.
2 weeks of time, my lords.
Thrice it was given already. Registry had given you opportunity thrice.
Do it.
ಬಟ್ ಅದಕ್ಕೇನ್ರ ಒಂದು ಕೊಡ್ಬೇಕು.
ಕೊಡು.
ಏನ್ ಕೊಡ್ತೀವಿ?
3 ಹೆಣ್ಣು 5 ಜಡೆ ಬೈ ಬೀಚಿ ಅವ್ರದ್ದು.
ಯಾವ್ದದು?
3 ಹೆಣ್ಣು 5 ಜಡೆ ಬೀಚಿ ಅವ್ರು.
3 ಹೆಣ್ಣು 5 ಜಡೆ.
It's a struggle about a family of 4 where 3 women are there in cosmopolitan city li ಎಷ್ಟು ಕಷ್ಟ ಜೀವನ ಅನ್ನೋದು.
ಓಕೆ. ನೋಡಮ್ಮ.
brought up.
ಆ ಬುಕ್ ಎರಡು ಕೊಟ್ಬಿಡ್ಬೇಕು. ಒಂದು ಹೈಕೋರ್ಟ್ ಲೈಬ್ರರಿಗೆ, ಒಂದು ಕೆಳಗಿನ ಕೋರ್ಟ್ ಲೈಬ್ರರಿಗೆ. 3 ತಗೊಂಡು ನೀವು ಒಂದು ಓದ್ಬಿಡಿ.
ಖಂಡಿತ.
ನಾವು ಇನ್ನೊಂದು ತಗೊಂಡು ಓದ್ತೀವಿ. But he used to use ತಿಮ್ಮ, ತಿ ಪೂಜೆ ಮುಂದ್ಗಡೆ ಆ ರೀತಿ ಮಾಡ್ಕೊಂಡು. ಓಕೆ, ವೆರಿ ಗ್ರೇಟ್ ಹ್ಯೂಮರಿಸ್ಟ್.
Yes, grateful.
Okay. ನೋಡಮ್ಮ, 2 weeks, subject to presenting 2 books. ಅದಕ್ಕೆ ಮಾಡಿ 2 books, namely Durgastamana by Tarasu. One to our library, another to that library. Failing which, the petition stands rejected. Yes. Debate copy. And wave ಮಾಡಿ.
Yeah. Your Lordship, praying for time to come.
5 times. ಏನ್ ಟೈಮ್ ಈಸ್ ಅದು ಅನಂತ ಕರೆಕ್ಟ್, ಆದ್ರೆ ನಮ್ ಜೀವನ ಅನಂತ ಅಲ್ಲ. ಅಲ್ವಾ? ನಮ್ದು ನಂತ ಮುಗ್ದು ಹೋಗ್ಬಿಡ್ತೇವೆ ಬೇಗನ. 5 ಸಾರಿ ಬಂದು ಹೋದ್ರೆ ದುಡ್ಡು ಕೊಡೋರೆ ಕೋರ್ಟಿಗೆ. ಒಂದು ಒಳ್ಳೆ ಪುಸ್ತಕ ಕೊಟ್ಬಿಡಿ. ಎಷ್ಟು ಸ್ಟೇಕ್ಸ್ ಎಷ್ಟು ಇನ್ವಾಲ್ವ್ ಆಗಿದೆ? ಎಷ್ಟು ಅಮೌಂಟ್ ಅಪೀಲ್ ನಲ್ಲಿ ಇರೋದು?
17 lakhs. 17 lakhs.
17 ಲಕ್ಷ. ನೋಡಿ, 2 ಬುಕ್ಸ್ ಕೊಡಿ, 2 ಬುಕ್ಸ್ ಕೊಡ್ಬೇಕು ನೋಡಮ್ಮ. ಸತ್ಯ ಮತ್ತು ಸೌಂದರ್ಯ ಒಂದು, ಸಾಹಿತ್ಯ ಮತ್ತು ಪ್ರತೀಕ 2 SL ಭೈರಪ್ಪನವರ ಗ್ರೇಟ್ ವರ್ಕ್ಸ್ ಇವು. ಇವುಗಳನ್ನು 2 ಅಲ್ಲಿ 2 ಇಲ್ಲಿ, ಆಯ್ತಾ? ಸಾಧ್ಯತೆ ನೀವು ಓದ್ಬೇಕು. ಒಳ್ಳೆ ಉತ್ಕೃಷ್ಟ ಪುಸ್ತಕ. ಸತ್ಯ ಮತ್ತು ಸೌಂದರ್ಯ, ಸಾಹಿತ್ಯ ಮತ್ತು ಪ್ರತೀಕ. ಎಂತ ಕ್ಲಾರಿಟಿ, ಏನ್ ಬರಹ ಮಿಸ್ಟರ್ ಶಂಕರ್, ದೇ ಆರ್ ಸೋ ಗ್ರೇಟ್. ತಲೆ ಮೇಲೆನೆ ಹೋಗ್ಬಿಡುತ್ತ ಅವ್ರು ಇವ್ರು ಓದಿರ್. ಅಲ್ಲ, ಖುಷಿ ಕೊಡ್ತದ ನಮಗದು. ಅವಾಗ ಕಾನೂನು ಹೆಂಗ್ ನೋಡ್ಬೇಕು ಇದೆಲ್ಲ ಎಷ್ಟೋ ಸರಿ ಅರ್ಥ ಆಗ್ತದೆ. ಎಸ್, ಭೈರಪ್ಪನವ್ರದ್ದು ಗೋವಿಂದ್ ಭಟ್ರ ಮುಂದೆ ಯಾವುದೋ ಒಂದು ಮ್ಯಾಟ್ರು ಒಂದು, ಹಂಬೇಗೌಡ್ರ ಮುಂದೆ ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ರು. ವಾಯಸ್ ಆಬ್ಲಿಗೇಷನ್ ಅಂದ್ರೆ ಏನು ಅಂತ. ಅವಾಗ ಹೊಂಬೇಗೌಡರು ಹೇಳಿದ್ರ, ನೀನು ಯಾವ್ದದು ಗ್ರಹಭಂಗ ಓದಿಯೇನು ಅಂತ ಕೇಳಿದ್ರಂತೆ. ಗ್ರಹಭಂಗ ಓದ್ಕೊಂಬ, ಆಮೇಲೆ ಗೊತ್ತಾಗ್ತದೆ, ಅಲ್ಲಿ ತನಕ ಗೊತ್ತಾಗ್ತದೆ. ಇನ್ನೊಬ್ರು ಯಾವ್ದೋ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಸ್ತಾ ಇದ್ದಾರೆ ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ, DP ಹಿರೇಮಠ ಸಾಹೇಬ್ರು ಒಂದು EP ಒಳಗಡೆ. ಅವಾಗ ಸಾಕ್ಷಿ ಮಾಡಿಸೋದಿತ್ತು. ಭೈರಪ್ಪನವ್ರು ಸಾಕ್ಷಿ ಓದಿಯೇನ್ ನೀನು ಅಂತ ಕೇಳಿದ್ರು. ಸಾಕ್ಷಿ ಓದ್ಕೊಂಬ, ಆಮೇಲೆ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಸು ಅಂತ ಹೇಳಿದ್ರು. ಅಂಥ ಕೃತಿಗಳು. ಆಲ್ ನೆಕ್ಸ್ಟ್, ಸಾರಿ, ಗೃಹಭಂಗ ಅಲ್ಲ, ವಂಶವೃಕ್ಷ, ವೇರ್ ರಾವ್ ರೈಟ್ಸ್ ಹಿಸ್ಟ್ರಿ ಅಂಡ್ ಕತ್ತೈನಿ ವಾಸ್ ಹಿಸ್ ವೈಫ್ ಅಂಡ್ ರಾವ್ಸ್ ಬ್ರದರ್, his son asks, ನೀನು ನಿಮ್ ತಂದೆ ಬರೆದಂತ ಎಲ್ಲಾ ಪುಸ್ತಕ ಓದಿಯಾ ಅಂತ ಹೇಳಿದಾಗ, ಇಲ್ಲ ನಾನೇನು ಅವ್ನು ಓದಲ್ಲ, ಅವು ನಮ್ಗೆ ಉಪಯೋಗ ಆಗಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಡ್ತಾನೆ. ಅದರಲ್ಲಿ ಬಹಳ ಮಜಾ ಇದೆ ಅದು. Whenever possible, just
hearing for the petitioner, my lords. Sincere apologies, my lords. I'll ensure that the objections are complied with if time may be granted, my lords.
ಒಂದು ಒಳ್ಳೆ ಸೆಕೆಂಡ್ ಟೈಮ್. ಓ ಲೈಫ್ ರಿಲ್ಯಾಕ್ಸ್ ಪ್ಲೀಸ್, ಒಂದು ಬುಕ್ ಕೊಟ್ಟು ಬಿಡಿ. ಅದೇ ಬೈ ನೋಡಮ್ಮ, ಸ್ವಾಮಿ ಸುಖಬೋಧಾನಂದ, ಒಳ್ಳೆ ಪುಸ್ತಕ, ಅದು ಓದಬೇಕು. ಓದಾಯ್ತಾ? ಆಲ್ ರೈಟ್, 2 weeks. ಎಸ್, ನೆಕ್ಸ್ಟ್. ಇದೆ ಬಲರಾಮ್ ಅವ್ರು ಸೇಮ್. ಏನಿದು? ಬೇರೆ ಬೆಂಚ್ ಆರ್ಡರ್ ಇದು.
Your lordship, praying for time, your lordship.
Non-filing of copy of for having served copy of so and so learned counsel agreeing for response by counsel for petitioners. ಏನ್ ಇಷ್ಟೆಲ್ಲ ಬಿಡ್ತಾರೆ? ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ ಇನ್ನು?
I'm not aware of it, your lordship, kindly.
ಕೊಡ್ಬೇಕಲ್ಲ ಅದನ್ನೆಲ್ಲ. ಎಷ್ಟು ದಿವಸ ಬಾರಿಗೆ ಬಂದು ಇದು ಈ ಬಾರಿಗೆ ಬಂದು?
RP copy has been served.
RP ಕೊಟ್ಟ, ಅಯ್ಯೇ ಕೊಟ್ಟಿಲ್ವಾ? ಮತ್ತೆ ಅಯ್ಯೇ ಕೊಡ್ಬೇಕಲ್ಲ. ಪಾಸ್ವರ್ಡ್ ಹೋಗಿ ಬೇಗ ನಿಮ್ ಸೀನಿಯರ್ಟಿ ಇಸ್ಕೊಂಬನ್ನ ಕೊಡಿ. ಪಾಸ್ವರ್ಡ್
Yes, sir.
The respondent, it may be taken up next week, my lord. The senior counsel Dhyan Chinnappa is engaged, my lord. He's
This
in,
matter.
yes, my lord, he is in the total one part.
All next week at the request of BDA council.
This interim order may kindly be.
Interim order to continue. Yes. 274 days. 5,448 ಕೊಟ್ಟು 408 ರೂಪಾಯಿ ಕೊಟ್ಬಿಡಿ. 274 ಕೊಟ್ಬಿಡಿ ಅವರಿಗೆ ಕಂಡೋನ್ ಮಾಡಿಬಿಟ್ಟು.
I'll give a book, my lord.
ಯಾವ ಪುಸ್ತಕ?
Lord, burn down your house. That is, my lord, provocations from,
Are you telling it to judges or what?
my lord, provocations from Kabir.
Vocation from Kabir.
Kabir. That's a book I'm reading now by one Hirmani. I've read
Okay. Hirmani. Yes, he is
by
the one.
Shabnam Veermani.
Hirmani.
Burn down your house, provocations from Kabir.
Price ಎಷ್ಟಿದೆ?
I think about 600 rupees.
600 rupees.
Two books, two books.
ನೋಡಮ್ಮ ಬರ್ಕೊಡಿ. 2 books. ಅಲ್ಲೇ ಸೇಮ್ ಫಾರ್ಮ್ಯಾಟ್ ಹಾಕೋಬೇಕು.
My lord, transfer pricing matter.
ಟ್ರಾನ್ಸ್ಫರ್ ಪ್ರೈಸಿಂಗ್
1 to
Howda?
5 may be admitted.
admitted on the following substantial questions of law 1 to 5. Next, other ಕೆಳಗಡೆ we have noted that some of these questions are being debated in an ongoing matter. Okay. Hello. So good format ಕೊಡ್ಬೇಕು ನಮ್ದಿದೆ ಅಲ್ಲ regular. Next.
180 days.
Notice, emergent.
Notice has to go.
ಆಗಿದೆ. ಇಲ್ಲ
Agila.
ಆಗಿಲ್ಲ. Notice, emergent notice.
There's a delay in the matter. Review petition is filed, my lord, seeking review of judgment of coordinate bench dated 19th of June 2023. Matter pertains to Entry Tax Act, my lords. Under the Entry Tax Act, first, there are only, unlike the other statutes, only scheduled goods can be taxed. Further, the rate of tax on the scheduled goods is by notification. So in the schedule, my lords, the relevant entry is spirits and alcohol, that is to say, denatured spirit, rectified spirit, and ethyl alcohol.
ಏನ್ ಡಿಫ್ರೆನ್ಸ್ ಎರಡಕ್ಕೂ? ಸ್ಪಿರಿಟ್ ಅಂಡ್ ಆಲ್ಕೋಹಾಲ್ ತಗೊಂಡ್ರೆ ಸ್ಪಿರಿಟ್ ಬರುತ್ತೆ ಅಂತ ಕೇಳೇವಪ್ಪ ನಾವು.
My lords, spirits and alcohol is used interchangeably. After that, there are three types, there are three subsets or species within that, which one is denatured spirits, the next is rectified spirit, the third is ethyl alcohol. Denatured spirit na, originally we had a notification which specifically covered denatured spirit. Adadmele, the next
scheduled goods rates are notified.
rates are notified. Then notification as to rate specifically covered denatured spirit. Thereafter, the expression denatured spirit was removed. Ethyl alcohol, which is the third item, it continues to be there in the schedule. Now, there is such a product which is denatured ethyl alcohol.
Whether it is covered or not.
Yes, which is whether it is covered or not. What happens, my lord, is that denaturing is basically the process of making it unfit for human consumption. Okay. What is done is about 5% of methanol is added.
These are all organic compounds.
Yes, my lords. Yes, my lord. By adding about 5% of methanol, it becomes unfit for human consumption and therefore can only be used for industrial petroleum use, etc., etc. My lords, in the judgment where I'm seeking review, two aspects, my lord. One, I succeed up to the tribunal. Assessing authority, first appellate authority, and tribunal hold in my favor.
That it is denatured
Ethyl alcohol is nothing but ethyl alcohol, and therefore continues to fall within the notification. The fact it is there,
not a different compound at all.
it is not a different compound at all. I have it,
Merely because
Yes.
it is made unconsumable humans.
yes,
By adding 5% some other thing.
methanol.
That does not cease to be denatured ethanol alcohol.
My lords. My lords. So that is one aspect, my lord. The second aspect, my lord, the judgment where I am seeking review in maybe because of my lord's
5% ಏನೋ ಅದಕ್ಕೆ ಏನು ಆಡ್ ಮಾಡ್ತೀರಿ ಅದನ್ನ ಡಿನೇಚರ್ ಮಾಡ್ಲಿಕ್ಕೆ?
methanol, methyl alcohol.
ಮಿಥೈಲ್ ಆಲ್ಕೋಹಾಲ್.
Methyl alcohol.
ಏನ್ ಅದ್ರದ್ದು ಸ್ಟ್ರಕ್ಚರ್, ಅದ್ರದ್ದು ಕೆಮಿಕಲ್ ಫಾರ್ಮುಲಾ? ಮಿಥೇನ್ is CH4.
ಮೀಥೇನ್ ಇಸ್ ಅದು CH4OH ಏನೋ ಇರುತ್ತೆ.
Correct.
ಅದು ಅದನ್ನ ಹೈಡ್ರಾಕ್ಸಿ ಮಾಡಕ್ಕೆ CH4OH ಏನೋ ಇರುತ್ತೆ. But I will, if I have to succeed, I'll have to make these submissions.
When that 5% ethanol is added, methanol is added, does it bring into existence a new organic compound in
No.
chemistry?
It is a mixture at best, my lord.
It's only a physical mixture
It is a mixture at
with
best.
no chemical reaction as such.
No. And the dominant nature remains ethyl alcohol.
It continues to be ethyl alcohol, but with physical mixture of 5% of ethanol.
Yes.
ಅದನ್ನ ಬೇರೆ ಅಂತ ಟ್ರೀಟ್ ಮಾಡ್ಯಾರ ನೀವು.
What has happened, my lord, is that there is
New compound not covered in the schedule at all ಅಂತ.
my respectful submission, my lords, is one, the tribunal is the last arbiter on facts. First submission. Second submission, my lord, there should have been, this is a plenary court, my lord, constitution court, we bow down, but there should have been some discussion, some scientific literature called for by me, appreciated, etc. The judgment, with utmost respect, my lord, does not do that, and therefore I am before your lordships in review.
I should tell one case that happened a century ago in England.
My lords.
Small village, Pudding Magna, on the seashore. A whale came, it was washed ashore. People were very happy. Such a big whale, and ಕಡಲ ಶ್ರಮನೇ ಬೇಕಿಲ್ಲ, ಎಷ್ಟೋ ದಿವಸಗಳನ್ನು ತಿನ್ಬೋದಿತ್ತು ನಾನು. ಅದನ್ನ ತಿನ್ನಕ್ ಶುರು ಮಾಡಿದ್ರು, ಬಟ್ ಎಷ್ಟು ದಿವಸ ಡಿಕೆ ಆಗದಂಗೆ ಇರ್ತದೆ. ಡಿಕೆ ಸ್ಟಾರ್ಟ್ ಆಯ್ತು, ವೆರಿ ಫೌಲ್ ಸ್ಮೆಲ್ ಎಲ್ಲ ಸ್ಟಾರ್ಟ್ ಆಗಿ, the people of that village, they gave a representation to the fisheries department saying that whale has fallen here, it is decaying. Therefore, why can't you take action to remove the carcass? ಅವರು ಏನು ಕೆಲಸ ಮಾಡಲಿಲ್ಲ, ಅದು ನಮ್ಮಲ್ಲಿ ಇದ್ದಂಗೆನೆ ಆಯ್ತು, ಅಲ್ಲಿಯೂ ಸಹಿತ ಇವ್ರಿಗೆ ಸಿಟ್ಟು ಬಂತು. ಇವ್ರು ಹೋಗಿ, ಏನ್ರಿ ನೀವು ನಮ್ಮ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಯು ಆರ್ ನಾಟ್ ಕನ್ಸಿಡರ್ಡ್ ಅನ್ಕೊಂಡು ಅವ ಅಲ್ಲೇ ಇದ್ದವನು ಇಮಿಡಿಯೇಟ್ಲಿ, whale is not a fish, therefore ನಮ್ ಡಿಪಾರ್ಟ್ಮೆಂಟಿಗೆ ಬರಲ್ಲ, ಫಿಶರಿ ಡಿಪಾರ್ಟ್ಮೆಂಟಿಗೆ ಬರಲ್ಲ, therefore application is rejected ಅಂತ ಕೊಟ್ಬಿಟ್ಟು. Then they went to the animal husbandry. ಅವ್ರು ಎನಿಮಲ್ ಹಸ್ಬೆಂಡ್ರಿ ಅವರು ನೋಡಿದ್ರು, ಅವ್ರು ಏನಪ್ಪ ಇದು ವೇಲು, ಇದೇನು ಎನಿಮಲ್ ಫಿಶ್, ಹೌ ಟು ಡಿಸೈಡ್ ಅಂತ ಅವರೊಂದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಮೇಲೆ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ರು ಎಷ್ಟೋ ದಿವಸ. ದೋ ಇಟ್ ಈಸ್ ನಾಟ್ ಎ ಫಿಶ್, ನೋಷನಲಿ ಇಟ್ ಈಸ್ ಟ್ರೀಟೆಡ್ ಆಸ್ ಫಿಶ್ ಬಿಕಾಸ್ ಇಟ್ ಲಿವ್ಸ್ ಇನ್ ವಾಟರ್ ಅಂತ ಅನ್ಕೊಂಡು ಅವ್ರದ್ದೊಂದು ರೀಸನಿಂಗ್ ನಿಂದ ಹಾಕ್ಕೊಟ್ರು. ಅಷ್ಟೊತ್ತಿಗೆ ಇದೆಲ್ಲ ಕೊಳ್ತು ಇದಾಗಿ ಎಲ್ಲ ಸಮಸ್ಯೆ ಆಯ್ತು. ಅಂಡ್ ದೇ ವೇರ್ ನಾಟ್ ಹ್ಯಾಪಿ. ನೀವು ಇಲ್ಲ ಅಂತೇಳಿ ನಾವೇನ್ ಮಾಡಬೇಕು ಅನ್ಕೊಂಡು ದೇ ವೆಂಟ್ ಟು ಅಟಾರ್ನಿ ಜನರಲ್ಸ್ ಆಫೀಸ್ ಅಂಡ್ ಗೇವ್ ಎ ರೆಪ್ರೆಸೆಂಟೇಷನ್. ಇವರು ವೇಲು ಫಿಶ್ ಅಲ್ಲ ಅಂತ ಇವ್ರು ಅಂತಾರೆ, ಅವ್ರು ಫಿಶ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು ಫಿಶ್ ಹೌದು ಅಲ್ಲೋ ಎನಿಮಲ್ ಏನೋ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಅಲ್ಲಿ ಇದ್ದಿದ್ದನ್ನು ರಿಮೂವ್ ಮಾಡ್ರಿ. ಇವ್ರು ಮಾಡೋದೇ ಇಲ್ಲ. ಕಡೆಗೆ ಅದು ಕೊಳತೆಲ್ಲ ಹಾಕೊಂಡು ಗಟ್ಟಿಯಾಗಿ ಬಿಸಿಲಿಗೆ ಎಲ್ಲ ಆಯ್ತು. ಅಲ್ಲಿ ಜನ ಏನ್ ಮಾಡಿದ್ರು, ಅದ್ರದ್ದು ಬೋನ್ಸ್ ಎಲ್ಲ ಹ್ಯೂಜ್ ಇತ್ತಲ್ಲ, ಆ ಬೋನ್ಸ್ ನಲ್ಲಿ ಸುಂದರವಾದಂತಹ ಕೃತಿಗಳನ್ನ ಮಾಡಿ ಲಂಡನ್ನದ 10 ಡೌನಿಂಗ್ ಸ್ಟ್ರೀಟ್ ನಲ್ಲಿ ಮಾರ್ಲಿಕ್ಕೆ ಶುರು ಮಾಡಿ. ಅವಾಗ ರಾಜ ಭಟ್ರು ಬಂದು, ವೇಲ್ ಈಸ್ ಅ ಪ್ರಾಪರ್ಟಿ ಆಫ್ ದ ಕ್ರೌನ್, ಯು ಹ್ಯಾವ್ ಟೇಕನ್ ದಟ್, ಯು ಶುಡ್ ಬಿ ಪ್ರಾಸಿಕ್ಯೂಟೆಡ್ ಬೈ AP ಹರ್ಬರ್ಟ್ಸ್ ಅನ್ಕಾಮನ್ ಲಾ ಅಂತ ಬುಕ್ಕಿದೆ, ಅದರಲ್ಲಿ ಹಿ ಹ್ಯಾಸ್ ಕೋಟೆಡ್ ದಿಸ್ ಕೇಸ್. ಹಂಗೆಲ್ಲ ಆಗ್ಬಾರ್ದು ಅಂತ. ನೀವು ಇಥನಾಲ್ ಇದು 5% ಆದಾಗೆ ಇದು ಹಿಂಗಾಗತ್ತೆ, ಇದಾದ್ಮೇಲೆ ಹಿಂಗಾಗತ್ತೆ. ಇಷ್ಟು ವರ್ಷ ವಿ ಕಾಂಟ್ ಸೇ ದಟ್ ಟ್ರೈಬ್ನಲ್ ಈಸ್ ಅನ್ ಅಥಾರಿಟಿ ವಿಚ್ ವಿಲ್ ಡಿಸೈಡ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಅಂಡ್ ಇಟ್ ಶುಡ್ ಹ್ಯಾವ್ ದಿ ಸೀಲ್ ಆಫ್ ದಿ ಕೋರ್ಟ್. ಹಂಗೆ ಹೇಳಿಕ್ಕಾಗಲ್ಲ. ಅದರ್ ಡೇ ಸೂರ್ಯನಾರಾಯಣಪ್ಪ ಸೇಯಿಂಗ್ ಯು ಕಾಂಟ್ ಸೇ ದಟ್ ವೇ. Overall, it all depends upon. So anyway, take notice letters, emergent notice. AP Herbert is a very curious writer on English legal history, uncommon law. Navella common law anteve. He called his book as Uncommon Law. He had criticized judgments of English courts, and he brought Lord Chancellor to write a foreword to his book. Lord Chancellor said, he has asked me to write the foreword because He wants to preempt contempt action ಅಂತ. ಬಹಳ ಚೆನ್ನಾಗಿದೆ ಅವನ ಬುಕ್ಸ್ ಎಲ್ಲ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಲೈಬ್ರರಿಲಿ ಇದೆ. ಅವುಗಳನ್ನು ಆರ್ಡರ್ ಮಾಡ್ಬೋದು ಇನ್ಮೇಲೆ. ಮಿಸ್ಲೀಡಿಂಗ್ ಲಾ, ಮೋರ್ ಮಿಸ್ಲೀಡಿಂಗ್ ಲಾ ಇದೆಲ್ಲ, ಲೀಡಿಂಗ್ ಲಾ, ಲೀಡಿಂಗ್ ಕೇಸ್, ಮಿಸ್ಲೀಡಿಂಗ್ ಕೇಸಸ್. ದಟ್ ಎಸ್
Obliged.
ಎಸ್ ರಾಜೇಂದ್ರ.
Lordship,
ಹಾ
I am before your lordship,
ಹೌದು.
the order passed by the TRAD Chennai,
ಹಾ
which has imposed pay number 81 to deposit 50% of the amount,
ಪ್ರೀ ಡೆಪಾಸಿಟ್ ಸೆಕ್ಷನ್ 18 ಇದು.
section 80, 50% ಕೇಳಿದ್ದಾರೆ. Your lordship can be reduced to 25%.
ಅಲ್ಲಿ ಪವರ್ ತೋರಿಸಿ, ಪವರ್ ಇದೆಯಾ?
Section 21 ನಲ್ಲಿ
ಓದಿ.
that can be reduced to 50%, 25% ಕೊಡ್ಬೇಕು ಅಂತ ಇದೆ.
ಎರಡು ಯಾಕೆ ಎರಡು ಅಪೀಲ್ ಇದಾವಲ್ಲ?
ಅಲ್ಲ, connected 13(4), 14 and sale ಒಂದೇ connected.
ಅದೆಲ್ಲದಕ್ಕೂ ಸಪರೇಟ್ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿದಾರ.
ಇಲ್ಲ, ಸಪರೇಟ್ ಕೊಡ್ಬೇಕು ಅಂತ, ಬಟ್ ಎಲ್ಲ ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ, ಸಪರೇಟ್ ಆರ್ಡರ್ ಮಾಡಿ 50% ಆಫ್ ದಿಸ್ ಅಂದ್ಬಿಟ್ಟು 3 ಕೇಸಲ್ಲೂ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಡೇಟೆಡ್ 1/8/2024 ಅಲ್ಲಿ therefore the petition appellant shall deposit 50% of the 8 crores, 50 lakhs, which comes to rupees 4,25,31,000 rounded off to so and so on or before 16/8/2024 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮೂರಲ್ಲೂ ಸೇರ್ಕೊಂಡು
3 ಸೇರ್ಸ್ ಅಂತ ಹೇಳಿ ಕಾಮನ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ. ಸಪರೇಟ್ ಆರ್ಡರ್ ಮೂರು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ದೀನಿ, 3 ಆರ್ಡರ್ಸ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಏನಂದ್ರೆ 25% ನಾನು ಏನಂದ್ರೆ ಅರ್ಲಿಯರ್ when I challenged the section 14 before DRT did not.
3 ಕ್ವಶನ್ ಮೇಲೆ ಅಪೀಲ್.
3 ಕ್ವಶನ್,
ಮೂರು ಕಾಜಸ್ ಇದೆ.
3 ಕಾಲ್.
ನಾವೇನ್ ಹೋಲ್ಡ್ ಮಾಡೇವಿ ಅಂದ್ರೆ 3 ಕಾಜಸ್ ಇದ್ದಾಗ ಒಂದೇ ಕಾಸ್ ಮೇಲೆ ಪೇಮೆಂಟ್ ಮಾಡಬೇಕು ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ವಿ.
ಮೊನ್ನೆ ಲ್ಯಾಂಡ್ ಮಾರ್ಕ್ ಜಡ್ಜ್ಮೆಂಟ್ ರಿಪೋರ್ಟೆಡ್
ಲ್ಯಾಂಡ್ ಮಾರ್ಕ್ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ.
ರಿಪೋರ್ಟೆಡ್
ರಿಟರ್ನ್ ದಟ್
ರಿಪೋರ್ಟೆಡ್ ಲ್ಯಾಂಡ್ ದಟ್ ಇಸ್ ಹೆಲ್ಪ್ಫುಲ್ ಟು ಆಲ್ ಬಾರೋಯರ್ಸ್.
ಆ ಪ್ರಕಾರ ಕೊಟ್ಬಿಟ್ರೆ ಮುಗಿದತ್ತು.
ಅದರಲ್ಲಿ 25% ನಲ್ಲಿ, ಯಾಕಂದ್ರೆ ನಾವು ಏನ್ ಮಾಡಿದ್ರೆ when ಚಾಲೆಂಜ್ ದಿ ಆರ್ಡರ್ ಪಾಸ್ ಬೈ ದಿ DC ಬಿಫೋರ್ DRT.
ಶೋ ದಿ ಪವರ್. 18 ನಲ್ಲಿ ಏನಂತ ಇದೆ? 18 we have interpreted in Dr. Vijay Mallya versus State Bank of India, LR 9 2019 ಕರ್ನಾಟಕ. ತೆಗಿದೆ, ನಮ್ ಪವರ್ ಇಲ್ಲ ಅಂತ ನಾವು ಹೋಲ್ಡ್ ಮಾಡ್ದಂಗ್ ಮಾಡೇನು.
ಇಲ್ಲ, that can be reduced. DRT has got the power.
18
Yes, my lord.
2018 ನಂತರ ಅಮೆಂಡ್ ಆಗಿದೆ ಏನಲ್ಲ ಇದು?
Securitization Act
ಅಲ್ಲ, ಈ ಸೆಕ್ಷನ್ ಏನಾರ ಅಮೆಂಡ್ ಆಗಿದೆಯಾ?
ಅದು ಮಾಡಿಯ ಕೆಮಿಕಲ್ಸ್ 75% ಮಾಡಿದ್ರು.
That's all right. Thereafter 18 is amended, na?
ಇಲ್ಲಿ ಸೆಕ್ಷನ್ 18 ನಲ್ಲಿ
50% of the amount of debt due from him as claimed by secured creditor.
yes, or that can be reduced to provided
Needs
also
to be recorded not less than 25%.
25%. 25% mandatory. That is a cut off. That can be
ಏನ್ ಮಾಡ್ತಾರೆ ನಿಮ್ ಕ್ಲೈಂಟ್?
rice mill, ಆಮೇಲೆ ಆಗ್ರೋ ಬೇಸ್ಡ್ ಇಂಡಸ್ಟ್ರಿ, MSME, ಉದ್ಯಮ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ. I am entitled for the concession, and moreover bank has classified my account as NPA on 7/4/2017. Intentionally 31/3/2017 ಮಾಡಿದ್ರೆ ಅದು ಕಟ್ ಆಫ್ ಡೇಟ್ ಆಗಿರೋದು. ಒನ್ ಟೈಮ್ ಸೆಟಲ್ಮೆಂಟ್, I was eligible for that. By postponing my classification NPA for 1 week, I was deprived from availing the benefit under vote scheme as on 31/3/2017. That is the gist of the case. Moreover, that 1 crore to 50 lakhs which the court ordered.
Take emergent notice, let us take emergent notice. The DRT is requested, DRT is requested not to
ಇಲ್ಲ, ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಈಗ.
ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿಬಿಟ್ಟಿದೆಯಾ?
ಮತ್ತೆ since I have not
Because
completed.
you have not complied with
Yes.
that. Take emergent notice.
Please, ma'am. Any short date?
Notice ಆಗಿ ಬರ್ಬೇಕು.
Public.
ನಾವು admission judges, we are not supposed to fix the date.
Yes.
ಅದು it amounts to saying matter should come before us.
No, man, I'm sorry.
Yes. Post immediately after service.
Petitioner is a professor of surgery in Government Hospital. Then what the Consumer Court members has passed the word that is at page 124. My specific jurisdictional issue that I raised was, it is a free service, therefore Consumer Protection Act is not applicable.
It is a,
Service is rendered free. Therefore, he is not a consumer
should be for consideration ಅಂತಿದೆ
for the
ಅದು.
consideration. ಅಂತಿದೆ. And after doing that, my lords,
ಅವರದ್ದು ಫೀಗಿ ಏನು ತೊಗೊಂಡೆ ಅಲ್ವಾ?
ಏನಿಲ್ಲ, there is no
Refund
fee. In
is-
fact, my lords, we have produced the records to show that 300 rupees registration fee was recorded, was taken. I assist in a scheme only that has been reimbursed thereafter. On that, there is no dispute. Now, my lord, the arrest warrant is issued. Advocate is up, even though in the execution case, my advocate appears, represents me. In spite of it, my lords, at page 156, await notice of JDRs 1 and 2, issue arrest warrant to JDR 3.
ಡಿಫಿಷಿಯನ್ಸಿ ಏನಾಗಿತ್ತು?
Deficiency in the surgery was conducted, my lords. There was no fault found with the surgery. Surgery at 6 ತಿಂಗಳಿಗೆ ಏನೋ side effect ಆಯ್ತು ಅಂತ ಹೇಳಿದ್ದೆ. Then, my lords, no expert opinion.
ಡೆತ್ ಆಯ್ತಾ?
No, death is not due to the accident. Long after this one.
No, the proximity between the
No, my
surgery
lords,
and the
it is
event.
not, it is not relatable to at all. And what they do is, no medical evidence is recorded. No evidence is recorded either of the complainant or of the, or of mine. I file an affidavit in opposition.
ಅದ್ರ ಮೇಲೆ ಮಾಡಿ ಹಾಕ್ಬಿಟ್ರು.
Other mail ಮಾಡಾಕ್ಬಿಟ್ರು. ಅದು under, by my specific contention is, they say, my lords, in 2 paragraphs, the tribunal said, the state commission says, I am right in contending it is free service. 2 paragraphs thereafter, since he has paid, it is not free service.
Emergent notice, interim order as prayed for till next date of hearing.
Great. Supreme Court remand matter transfer proceeding. Question 3, 4, 5, my lord.
ನೋಡಮ್ಮ 3, 4, 5 ಗೊತ್ತಾಗತ್ತಾ? ಎಸ್ ಅಲ್ಲಿ we have noted ಅಂತಿದೆ ಅಲ್ಲ, ಅದನ್ನಲ್ಲಿ ಆಡ್ ಮಾಡ್ಕೋಬೇಕು. ಎಸ್
Transfer pricing matter, my lord. Question, substantial question 1 and 2.
ನೋಡಮ್ಮ 1 and 2 ಅಲ್ಲಿ ಕೆಳಗಡೆ ಬರೀಬೇಕು ಆನ್ಗೋಯಿಂಗ್ ಮ್ಯಾಟರ್. ಎಸ್
Lordship, it may be disposed of on basis of tax effect being less than prescribed limit
ನೋಡಮ್ಮ
with liberty.
disposed of with liberty. Format ಕೊಡಿ. Do you have that format? 9 of
9 of
24.
24, my lord.
9 of 24 CVD. Okay.
Lordship, I have raised 5 questions, my lord. The first, the the assessee is a mining company, my lord. The assessment year is 2014-15.
The government company.
Government. The assessee is a mining company, my lord. Assessment year is 2014-15. The assessing authority made 2 types of disallowances, my lord. The first disallowance is in respect of a penalty paid by the assessee, my lord. Penalty paid by the assessee to an extent of 6 crore 92 lakhs, my lord, to paid to Central Empowered Committee, CEC, constituted by the Honorable Supreme Court. That is one penalty that has not been allowed by the assessing authority on the ground that it is not meant for, under section, it should, and 37, it should be for wholly and exclusively for business purpose. Since this is a penalty, explanation 1 says if anything is paid in lieu of an offense committed, it is not allowable.
Correct ಇದೆ ಅದು.
Therefore, this disallowance has been made by the assessing authority. The tribunal has followed its earlier order in case of.
Where is the fault in that ಅಂತ?
Your Lordship, the tribunal set aside the disallowance, Lord. disallowance has been made by the assessing authority since this amount.
Disallowance is correct because it
Yes,
is not part of the business expenditure at all.
Yes, my lord, that disallowance has been set aside by the tribunal and before this honorable court, my lord. The tribunal has followed its earlier order.
Requires consideration.
I just saw the name. It is wrongly written as V. Chandrasekhar. Your lordship may write it as V. Chandrasekhar. My lord will take notice.
ಅದೇ
I leave it to your lordship.
ವಿ ಚಂದ್ರಶೇಖರ
You have not filed.
ಹೆಸರನ್ನು change ಮಾಡ್ತೀವಿ ಸರಿಯಾಗಿ
We'll take notice.
admit emergent notice ಅಲ್ಲಿ admitted on the following substantial questions of law. ಯಾವ್ದು
1 to 5 minutes.
1 to 5 emergent notice.
Please.
ಅಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆ ಈಗ
Notice ಆಗಿದೆ, ಅವರು ಅಪೀರ್ ಆಗಿದ್ದಾರೆ.
ಹೆಸರಷ್ಟ ಚೇಂಜ್.
Yes, yes.
Okay. Mr. Shankar, business expenditure ಅಂದ್ರೆ ಏನು? Suppose penalty ಇಂಥದೆಲ್ಲ ಕೊಟ್ಟಿವಪ್ಪ. That's also in connection with business also. ಆಗಲ್ವಾ?
In some cases,
It is
courts
held.
have held, it is to be allowed. In some cases, it's in infraction. See, there are, like, for example, my lord, section 234B, interest is levied under the Income Tax Act. It substituted an earlier penalty and interest provision and made as interest. So, but interest is not allowable under the scheme of the act, what you pay under the act, so it will not be allowed. Prakash Cotton, in the
Yes.
Supreme Court case, my lord, tomorrow I'll leave it. That is one of the most important cases on
On
what-
this.
on this issue, my lord. What exactly, when the penalty is allowable, when it is not allowable. In all cases, it is not saying that it is not allowable. Some-
ಅಲ್ಲೇನೋ sufficient cause ಅಂತ ಅನ್ಕೊಂಡೇನೋ
that sufficient cause is when a penalty is levied by the department, I can pose sufficient cost. That is a different issue.
Okay.
Your lordship are queried me on,
whether penalty
can be
itself.
allowed as an allowable
Al-
expenditure.
expense.
See, income is computed from section 28 to 45 of the 44 of the Income Tax Act, as well as income from business. In computing that business income, whether I have paid penalty to corporation for not paying the
House tax.
house tax
related.
or building tax, which I am doing, or my factory building. So whether it is allowable or not. Whether it is for infraction of law or penalties are for delay. Delay in making, so some acts have penalty, the nomenclature is penalty, but in effect,
They are not.
they are not penalty because I have not paid it in on a 30th June. They will say you have to pay 20% more in the nature of penalty in the statute. Those courts have held, those are not in the infraction of law. What is infraction of law is one thing, what is the statute itself calls it a penalty, but actually it is not actually infraction of any law. Delay,
A nomenclature per se will not
it's
decide.
not decided. Well settled, madam.
Suppose
Nomenclature
ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್ ಕಾರು ಅಲ್ಲಿ ನಿಲ್ಸಿರ್ತಾರೆ, ಅದು ರಾಂಗ್ ಪಾರ್ಕಿಂಗ್ ಅನ್ಕೊಂಡು ಪೆನಾಲ್ಟಿ ಆಗ್ತದೆ.
penalty ಆಗಿದೆ.
ಅದನ್ನು ಬಿಸಿನೆಸ್ ಹೌದು ಅಲ್ಲೋ ಅಂತ ಅನ್ನೋ ಪ್ರಶ್ನೆ
But
ಬರ್ತದೆ.
now, naturally, is a book, entity of the business. Whereas I ought to have done in a particular manner. I have not done it. For that, a notice has been issued. I am not able to demonstrate reasonable cause for not levying the penalty. And a penalty per se has been levied, which is nomenclature, it is not something which is not in the nature of an allowable expenditure. I will send and copy of the judgment.
ಸೆಕ್ಷನ್ 95 of the ಕರ್ನಾಟಕ ಲ್ಯಾಂಡ್ ರೆವೆನ್ಯೂ ಆಕ್ಟ್ ಕೆಳಗಡೆ
Sure.
ದೇ ಹ್ಯಾವ್ ಟು ಡೆಪಾಸಿಟ್ ದಿ ಫೈನ್ ಅಮೌಂಟ್ ಅಂತ ಫೈನ್ ಅಂತ.
Fine. Yes.
ಅದು ಫೈನ್ ಆಗದೆ ಇಲ್ಲ ಅದು.
Correct.
ಅದನ್ನೇನೋ ಫೈನ್ ಅಂತ ಕರೆದ್ರು ಅವ್ರು. ಆಮೇಲೆ ಯಾಕೆ ಹಿಂಗ್ ಕರೆದಾರೆ ಅಂತ ನೋಡ್ತಾ ಹೋದೆ ನಾನು. ಅದು ಬಾಂಬೆ ಲ್ಯಾಂಡ್ ರೆವೆನ್ಯೂ ಕೋಡ್ ನಲ್ಲಿ ಆ ವರ್ಡ್ ಉಪಯೋಗಿಸ್ಯಾರ ಅಲ್ಲಿ ಆ ಟೈಮ್.
So yesterday, they brought in a new code for income tax.
ಹೌದು.
They have announced it, my lord. Parliament, are in place and it's going to go to select committee. Now, all the sections 148 will become 268. We had 1922 Act, we had 1961 Act, now we are going to have 2025 Income Tax Act. Very, very more complex than the present one. Under the guise of simplification, only complications will happen. Good for lawyers. Annadata Sukhi Bhava.
ಸುಖಿ ಭವ.
Lord, there is one explanation to section 37, which says, my lord, for the removal of doubts, it is hereby declared that any expenditure incurred by the SSC for any purpose which is an offence or which is prohibited by law shall not be deemed to have been incurred for the purpose of business or profession, and no deduction or allowance shall be made in respect of such
So
expenditure.
explanation is
So,
also there.
Specifically, it is.
That is, based on this only, the interpretation came because what is an
Even
offence?
their interpretation is necessary.
Offence must be there. If I have not paid the corporation tax and the department collects fine or penalty, there's no offence. Delay cannot be treated as that. That is why that a lot of case laws are there on the subject. I have a compilation of it. I'll send one for your lordship. I know your lordship will read. Anyhow, one thing, my lord, my friend, if you go to his house, my lord, you can't find anything other than books. That is why he's ready with the name of the books every day. In fact, I know his family, he told his children when he was young, don't ask me wealth, don't ask me education, but you ask me book, I'll get you books. Whenever his children have asked books, full, left, right, all around. In fact, it'll be full of books. I mean, sorry, I should not be.
But
telling-
No, wait, sir.
He's a
It's a
very
very
dear
great
friend
thing,
from
because
early on.
whenever we quote some books, he will be saying, no, this is the author.
And
but
most
immediately
of them
he
would have
says,
read it also. In fact,
ಓದ್ಬೇಕು,
But after he came to Bangalore, my lord,
ಓದ್ಬೇಕು.
professional.
ಹೀಗಾಗಿ ನಮ್ಮ ಸಿದ್ದಯ್ಯ ಪುರಾಣಿಕರದಿದೆಯಲ್ಲ, ಓದಿ ಬ್ರಾಹ್ಮಣನಾಗು, ಕಾದಿ ಕ್ಷತ್ರಿಯನಾಗು, ಏನಾದರೂ ಆಗು, ಮೊದಲು ಮಾನವನಾಗು.
ಮಾನವನ.
ಚಂದಿದೆ. ಎಸ್.
27 would, my lords, take it up after 4 weeks. The assessee has filed a VSV application.
You have filed that. ಇದು ನಿನ್ನೆ ಬಂದಿತ್ತಾನೆ ಇದು? Yesterday it was posted.
No, no, my
Not
lords, it's
this.
a different matter.
Application ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿ.
ಮಾಡ್ತೀನಿ.
Suppose ಅದು against ಆತು ಅಂದ್ರೆ you can seek review, recall of the order. And dispose of ಮಾಡೋಣ?
ಇಲ್ಲ.
ಬೇಡ.
ಅವ್ರಿಗೆ
It's our appeal, so
Appeal.
it'll have to
Yeah,
be.
they have filed
Yes, ma'am.
vivad se vishwas.
Yes.
we'll consider it. It may be adjourned for 2 weeks, madam. We'll do it.
All right. Call after 2 weeks. First off, learned panel counsel appearing for the revenue submits that he would instruct the concerned authority to hear and dispose of the application filed by the assessee under Vivad se Vishwas scheme,
Yes,
comma, in accordance with law.
please.
Okay.
Let's appear for the
My lords, arguing counsel in Cisco Systems India. My lords, item 29 has been taken now.
28. Wait.
Hold.
You are in the queue.
Yes, sir.
Wait, yes.
My lords,
Ah.
matter pertains to the VAT Act. Under section 11 of the VAT Act, the law says that with respect to certain items, input tax will not be claimed, shall not be claimed. Then it goes to section 14, which is introduced as a special rebating scheme, which says that, look, under 11A, 5 and 6, I will allow you to claim input tax credit with respect to the input tax charged at a rate
First section ಯಾವುದು?
14, ma'am.
Certain things are not
Not deductible.
not deductible at all.
11A, my lords.
11A, input tax shall not be deducted in
In-
calculating the net tax payable in respect of
Following. Then my lords may kindly come to 14.
So 11 prohibits deduction.
Prohibits deduction.
Yes.
My lords may kindly come to 14.
Fourteen.
Deduction of input tax shall be allowed on purchase of goods specified in clauses 5 and 6 of 11A to the extent of the input tax charged at a rate higher than 4% or any lower rate as may be notified.
So this is in the nature of an exception to section 11.
Precisely. A limited exception, which is if the input tax is higher than 4% or
Then deduction.
then deduction. And 5 and 6 in 11, your lordships may see. One deals with purchase of goods that are dispatched outside state or inputs in manufacture. And the second deals with petroleum natural gas,
ಇಲ್ಲಿಂದ ಹೊರಗೆ ಕಳಿಸಿದಂತ goods,
interstate trade,
interstate trade.
where your lordships, the CST tax, the central sales tax used to become applicable. And therefore that rate of 4% or any higher
Sale ಅಲ್ಲ, very purchase ಮಾತ್ರ.
purchase. The sum and substance, my lords, is that 14 operates as a limited exception to 11, A with respect to 5 and 6, and 2 with respect to extent of input tax charged at a rate higher than 4% or other rate that may be notified.
ಅದು condition ಅದು.
It's a condition, precisely. Now, what happens in this matter, my lords, is that my expectation is that this is the statute. If you are claiming the benefit of 14 as an exception to 11, please include it in your return.
11, 5 and 6.
Yes. If you are claiming the benefit of 14 as an exception to 11, 5 and 6, to the extent provided for in 14, please claim it in your returns. He does not do so. Tribunal glosses over this and says this is a technical matter. Your lordship,
IT ITR ನಲ್ಲೇ ಅದು ನಿಮ್ದು ಇದು ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ ನಲ್ಲೇ ನೀವು ಕ್ಲೇಮ್ ಮಾಡ್ಬೇಕಿದ್ ನಾನು.
claim ಮಾಡ್ಬೇಕು.
ಇಂಡಿಪೆಂಡೆಂಟ್ಲಿ ಕ್ಲೇಮ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ ನಿಮ್ ಕಂಟೆಂಟ್.
ಆಮೇಲೆ ಮಾಡಕ್ಕಾಗಲ್ಲ, 240 ಆಡಿಟ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಇನ್ನೊಂದು ಯಾವ್ದು ರಿಟರ್ನ್ ಹಾಕಿ ಅದ್ರಲ್ಲಿ ಮಾಡಕ್ಕಾಗಲ್ಲ, at the time of scrutiny assessment ಮಾಡಕ್ಕಾಗಲ್ಲ. It is written or revised return as permitted within period of 6
In
months.
other words, if you want to take the benefit of 14, the procedure prescribed is mandatory. ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಿ.
Precisely.
ಮೇಲೆ ಏನಂತ ಹೋಲ್ಡ್ ಮಾಡ್ಯಾರ ಈಗಾಗಲೇ.
Now tribunal treats it as if,
courts have held on that.
well, it's this honorable court in 3 judgments, I have said that the return is must. It is a mandatory requirement. It is not a technical requirement. My learned friend will say that some of these judgments are pending before the Supreme Court. I will therefore, my lord, submit what the Supreme Court says in Jayam and Company.
Are you a psychologist?
No.
How you will know what he is going to argue?
My learned friend is,
Just
it just so happens, my lord, that in the same assessee has the same problem before this bench in a number of cases. Court of Court. I will come to the 3 judgments of the,
ಅಲ್ಲೇನೋ ಅದರಲ್ಲಿ ಅದು ಎಕ್ಸೆಪ್ಷನ್ ಈ ಕಂಡೀಷನ್ಸ್ ಇದೆ.
yes.
ಈ ಕಂಡೀಷನ್ ಕಂಪ್ಲೈ ಮಾಡು, ಬೆನಿಫಿಟ್ ತಗೋ, ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಇಲ್ಲ.
Your lordships may kindly come straight away to paragraph 11, my lords. From the aforesaid, and this is not an isolated judgment, any number of judgments, but I thought I will place the one that crystallizes it. From the aforesaid scheme of section 19, following aspects emerge. ITC is a form of concession provided by the legislature. It is not admissible to all kinds of sales, and certain specified sales are specifically excluded. Concession of ITC is available on certain conditions mentioned in this section. One of the most important conditions is that in order to enable the dealer to claim ITC, it has to produce original tax invoice, completed in all respect, evidence the amount of input tax. Here, the invoice may not be an issue, but it is a question of return. But I'm on the principle.
Invoice completed in all respect.
Evidencing the amount of input tax.
ಅದನ್ನ ಇದರಲ್ಲೇ ನಿಮ್ಮ ರಿಟರ್ನ್ ಅಲ್ಲೇ ಕೇಳಬೇಕು ಅನ್ನೋದು ಎಲ್ಲಿ ಡಿಸೈಡ್ ಆಗಿದೆ?
ಇಲ್ಲ, I'll come to that. This honorable court said. But I'm relying on the next paragraph.
12.
My first submission is ITC is a concession. Next, it is trite law that whenever concession is given by statute or notifications,
What is meant by trite?
ordinary, small,
ನೋಡಪ್ಪ, ಶಬ್ದದ ಅರ್ಥ ಬೇರೆ ಇದೆ. ಯಾಕಂದ್ರೆ ಸ್ವಲ್ಪ ನಾನು ನೋಡಿದೆ ಮೊನ್ನೆ ಅದು why they say do not know. Trite ಅನ್ನೋ word ಅದು meaning ತೆಗಿ.
commonplace, ordinary, small.
Trite, TRITE. It lacks originality of freshness. Means from the old ಅನ್ನೋ ಅರ್ಥದಲ್ಲ. ಮೀನಿಂಗ್ ಹಿಂಗಿದೆ ನಮ್ಗದು. ನಾನು ಈ ಸ್ವಲ್ಪ ಶಬ್ದ ಉಗಮ ಶಾಸ್ತ್ರದ ಮೇಲೆ ಸ್ವಲ್ಪ ವರ್ಕ್ ಮಾಡೇನ್ ನಾನು, ಎಟಿಮಾಲಜಿ ಮೇಲೆ ಇಂಗ್ಲಿಷು ಕನ್ನಡದಲ್ಲಿ. ಅವಾಗ ಇದು ನೋಡಿದೆ ನಾನು ಜಸ್ಟ್ ಅಬೌಟ್ ಎ ಇಯರ್ ಬ್ಯಾಕ್ ಆರ್ ಸೊ. ರೈಟ್ ಅಂದ್ರೆ ಏನು? ವೈ ವಿ ಯೂಸ್ ದಟ್ ವರ್ಡ್ ರೈಟ್?
Lacking originality or freshness, dull on account of overuse.
ಡಲ್
On account of overuse. ಅದಕ್ಕೆ ಕಾಮನ್ ಪ್ಲೇಸ್ ಅಂದೆ.
ಆ ಅರ್ಥದಲ್ಲಿ.
This is from the Oxford Dictionary.
That's what. Anyway,
It is trite law that whenever concession is given by statute or notification, the conditions thereof are to be strictly complied with in order to avail such concession. Thus, it is not the right of the dealers to get benefit of ITC, but it is a concession granted by virtue of section 19. As a fortiori conditions prescribed in section 10 must be fulfilled. In that hue, we find that section 10 makes original tax invoice relevant. Therefore, under the scheme of the act, it is not permissible for the dealers to argue that the price indicated should not have been taken into consideration at purchase, so and so, so and so. If you were dealing with any other aspect, dehorse the issue of ITC, possibly the arguments of Mr. So and so would have assumed some relevance. But in keeping with the scope of the issue, such a plea is not admissible. So this judgment, my lord, treats ITC as a concession and says that
condition should be complied with.
conditions should be complied with.
ಅಲ್ಲೇ ಅದೆಲ್ಲಿದೆ? It should be claimed only in the return ಅಂತ ಎಲ್ಲಿದೆ?
My lords. Your lordships may next
ಸೆಕ್ಷನ್ ಎಲ್ಲಿದೆ?
35.
35 ಅಲ್ಲಿ ಇದೆಯಾ?
Ida. And it has been interpreted by division bench of this honorable court.
Prescribes conditions for availing input tax benefit.
Yes. And read with 10, my lords.
Section 35 read with
10.
ಓದಿ ನೋಡೋಣ. ಹಂಗಿದೆಯಾ? ಆ ರೀತಿ ಇದೆಯಾ? ರಿಟರ್ನ್ ನಲ್ಲೇ ಕ್ಲೇಮ್
Yes, sir.
ಮಾಡಕ್ ಇಲ್ವಾ?
Kindly see, my lords. Kindly see. 10(3). Subject to input tax restrictions specified in 11, 12, 14, 17, 18, 19, net tax payable by registered dealer in respect of each tax shall be the amount of output tax payable by him in that period, less the input tax deductible by him as may be prescribed in that period, shall be accounted for in accordance with the provisions of this act. Provided that a registered dealer, while calculating the net tax payable on or after the first day of April 2015, may claim input tax relatable to the goods purchased in the period immediately preceding 5 tax period or such tax period, if the input tax goods is not claimed, so and so.
5 preceding tax periods.
5 preceding tax periods.
ಅಂದ್ಮೇಲೆ ಅದರಲ್ಲೇ ಇರಬೇಕು ಅಂತ ಕಾಂಟ್ರರಿ ಆಗ್ತದೆ ಕಂಟೆನ್ಷನ್.
This is after 2015.
ಪೀರಿಯಡ್ ಅನ್ನ ಇಷ್ಟು ಪೀರಿಯಡ್ ನಲ್ಲಿ ಯಾವಾಗಾದ್ರೂ ನೀವು ಕ್ಲೇಮ್ ಮಾಡ್ಬೋದು. ಯಾಕೆ 5 ಅಂತಂದ್ರೆ ಯಾಕೆಂದ್ರೆ ಬಜೆಟ್ ಗೌರ್ಮೆಂಟ್ ಆರ್ಶ್ ಬರೋದು 5 ವರ್ಷಕ್ಕೆ ಒಂದ್ಸಾರಿ.
5 months.
ಇಂಥದ್ದು ಏನೇನೋ ಒಂದು ಇರ್ತದೆ ಅಲ್ಲಿ. ಬಟ್ ನಿಮ್ದ ರಿಟರ್ನ್ ನಲ್ಲೇ ಕ್ಲೇಮ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದು ಎಲ್ಲಿದೆ ಅಂತ. ಅದು ಇಫ್ ಇಟ್ ಇಸ್ ಎ ಸ್ಟ್ಯಾಚ್ಯೂಟರಿ ಕಂಡೀಷನ್, then we will go for further things, whether that condition is mandatory, not mandatory. These things we can think of. ಆ ಕಂಡೀಷನ್ ಎಲ್ಲಿ ಆಯ್ತು? ಸೆಕ್ಷನ್ 10(3) ದಲ್ಲಿ ಎಲ್ಲೂ ಕಾಣ್ತಾ ಇಲ್ಲ ಅನ್ನೋದು ನಮ್ಮ ಇಂಪ್ರೆಷನ್.
It is the 5 tax periods is tax period is a month under the VAT Act.
Not year.
Not year.
5 tax periods. But every time ರಿಟರ್ನ್ ಹಾಕ್ತಾನ ಅವನು.
Return ಆಗ್ಬೇಕು.
ಆ ರಿಟರ್ನ್ ನಲ್ಲೇ ಇರ್ಬೇಕು ಅಂತ ಹೇಳಿ ಆಗ್ತದೆ. ಅದಕ್ಕೆ ಕಾಂಟ್ರರಿ ಆಗ್ತದೆ ಲ್ಯಾಂಗ್ವೇಜ್.
ಇಲ್ಲ. It is, this honorable court says so.
They have said that.
Just clarify here that proviso has been inserted only with 2015. Before that time period was also not there. This assessment is 789.
30.
Assessment before your lordships in this matter is 2008-9.
That goes against you.
No, this proviso has been inserted.
That goes against you.
It doesn't
Because
go
we are saying
The court has said, before the proviso, there was no time limit. I could have claimed the input
At
tax
any
credit
time.
at any time. Our court has
the
said.
question is not that.
Correct.
You are on limitation period.
No, we are not on limitation.
5 years means 5
years.
They are not an
five periods is a limitation period.
ಈಗ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ
ಅದನ್ನ ಮರ್ತ್ಬೋಣ. Question is not that.
whether it has been
is-
claimed in the return or not.
Your
That is
lordship
the
may
question.
kindly take page, rule 38 of the rules, my lord.
Rule 38.
Rule 38 of the rules. It will be immediately following the act.
ಅಲ್ಲೇ ನೀವು section 10
Section 35, 10(3),
10(3).
rule 38, and then I will take your lordships to section 38.
Rule 38
First rule 38.
submission of monthly return.
Yes, every registered dealer shall submit a monthly return. It is obligatory. Or quarterly return, my lords, there is a threshold, I think 25 lakhs or less. The tax period is quarterly, but otherwise everything is monthly. As the case may be, containing value of sales, purchases, other transactions, input or output tax claimed and collected. Your lordships may mark that. And net tax relating to all of this.
So it has to be in that only ಅಂತ ನಿಮ್ contention.
Yes.
Because it is prescribed in the rule ಅಂತ.
Your lordships may now come to section 38.
38. ಇದು rule ಆಯ್ತು.
Rule ಆಯ್ತು. Section 38.
Assessment of tax.
Yes, 38(1). Every dealer shall be deemed to have been assessed to tax based on the return filed with him by him under section 35. So this return, my lords, has been treated until I invoke my power of reassessment or scrutiny assessment. This return is nothing but the assessment.
That return itself is an assessment, unless you go for further steps in respect of this.
Yes, yes, yes. The regime is one of self-assessment. 38 requires him to mention all of this. It is required to be filed in a timely manner. The schedule is given, and this is nothing but the assessment. My reassessment, my scrutiny assessment is based on this itself.
You may choose to, you may not do it also.
Yes, I may have some internal triggers based on volume, intelligence reports, difference in various.
You said, you mentioned also section 35. Why?
35. 35 is the requirement to file the
Returns.
and rule 38 provides the contents of those returns, manner of filing them.
How this court has held.
My lords, I just passed on that side. Judgment, RR judgment.
ಅಲ್ಲಿ ಒಂದು ನಿಮಿಷ ಬರ್ಕೊಳ್ಳುತ್ತೆ. Learned AG submits that input tax claim is only a concession, although regulated by statute. Simple. Rule 38 read with section 38 and section 10.
35, 38, 10.
35, 38 and section 10 of the act prescribes what all to be contained in a return, and it includes the claim for input tax concession. And therefore, claim dehors the return for input tax concession is not entertainable. First, in support of his contention that input tax concession is purely a concession as such, he invokes Jairam and Company versus Assistant Commissioner 2016, 15 SCC 1 to 5, paragraph 11 and 12.
There are other judgments, ALD, automotive, etc. I'll come to them. My lords, before I show your lordships the judgment of the Honorable Karnataka High Court, your lordships may kindly see 35.4. 35.4, section 35.4. My apologies, my lord, I omitted.
all
My young friend has pointed it out.
If any dealer
Having furnished a return under this act, other than a return furnished under subsection 3 of 38, discovers any omission or incorrect statement therein, other than as a result of an inspection or receipt or any other information or evidence by the prescribed authority, he shall furnish the revised return within the time limit, time prescribed for filing the return for succeeding tax period, and he shall furnish the revised return anytime thereafter, but within 6 months from the end of the relevant tax period, if so permitted by prescribed authority. So he can either revise it,
although he shall furnish is a mandate. So where law requires something to be done and if he does not do, then this section says mandate.
yes, my lord.
You have to do that.
Yes, my lord.
But this is not a mandate. He may seek input claim, he may not seek. it.
Precisely, my lord. If he is not claiming input tax credit, if he does,
This section,
my lords,
which enacts a mandate, may not be in respect of input tax concession at all.
it can be any error or omission, my lords.
Error of omission ಹೆಂಗಾಗ್ತದೆ?
ಇಲ್ಲಿ ಬರ್ತಿದೆ.
Shall ಅಂತಿದೆ ಅಲ್ಲಿ.
Yes. If any dealer having furnished a return
That's all right.
discovers any omission or incorrect statement therein,
Incorrect ಆಗಲ್ಲ ಇದು. ನಾನು ಕ್ಲೇಮ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ incorrect statement ಆಗಲ್ಲ ಅದು. It's a concession. I may avail, I may not avail. So duty enacted in this section, what is required of him in law,
correct.
not in respect of concession at all.
So it is therefore extrapolated that if he forfeits it, does not avail the opportunity, then it is gone forever. He first consciously said, "Nangu bekalla. I am above this. I want to contribute to the betterment."
Any
of the
judgment which says in terms of this, he can add input tax claim under this also.
No, it's the, kindly see, my lords, what coordinate bench says in 2014, 5 KCCR, ILR 2015, Karnataka 57, my lords. State of Karnataka versus Centum.
Page
Your lordships may kindly come to
9.
9, para 9. There is some discussion, but from a reading of the aforesaid provision, it is clear that output tax is a tax payable by any dealer on the sale of goods made by him in the course of business. Input tax is a tax collected by the registered dealer or payable under this act on the sale to him of any goods for the use in course of business. Subsection 3 of 10 provides for calculating the net tax payable. It provides that the net tax payable by a registered dealer shall be the amount of the output tax payable by him in that less the input tax deductible by him as may be prescribed in that period and shall be accounted for in accordance with the provisions of the act. Therefore, it is clear that in that period specifies the period during which input tax is paid and output tax is payable, and the same has to be accounted in accordance with the provisions of this act. Subsection 4 makes it clear that for the purpose of calculating the amount of net tax to be paid or refunded, no deduction of input tax shall be made unless a tax invoice, debit note, credit note in relation to a sale has been issued in accordance with section 29. The act prescribes so and so, then 35 is extracted. Para 11. Subsection 1 of 35 provides for furnishing a return in such form and manner and for payment of tax due on such return within 20 days or 15 days after the end of the preceding month or any other tax period as may be prescribed. Therefore, the statute provides the period within which a return is to be filed under 35(1), that is, within 20 days after the end of the preceding. Section 2 mandates that the tax on any sale or purchase of goods declared in a return shall become within 20 days or 15 days of as prescribed under subsection 1 of 35 without the assessee waiting for a notice for payment of such tax. Subsection 4 of 35 provides that filing of a revised return if the assessee discovers any omission or incorrect statement in the omission, my lords, if he has omitted.
Therefore, the statute provides for filing of
Yes.
a return claiming input tax rebate.
Claiming input tax credit.
Rebate alva.
Therefore, the statute provides for filing of a return claiming input tax rebate within the period prescribed in law. if in the return filed there is any omission or incorrect statement, a provision is made for filing of a revised return within the time prescribed. If the returns are not filed within the set period, then the assessee would not be entitled to the benefit of setting off output tax against the input tax. Then, my lords, the contention of the assessee is recorded and the reliance on K-bond polymers is recorded, my lords. Your lordship will take para. In the instant case, para 14, assessee paid input tax for the month of June 2006. In the returns filed in July 2006, he did not put forth any claim. He also did not file any revised return within 6 months, putting forth the said claim. That is the period prescribed under law for 35(1) and 35(4) of the Act. It is only in the return filed in the month of February 2007, after expiry of the aforesaid period, he put forth the said claim. Therefore, the assessing authority was well within, as well as the first appellate authority, rightly held that the claim for output tax, for input tax rebate.
It went more on limitation period.
Yes.
Judgment went more on limitation period than the requirement of claim being made in the return itself. Though the earlier,
Yes.
this one gives.
11 says so.
impression.
End of
Yeah.
11 is what I'm relying on.
Therefore, the statute provides for filing of a return claiming input tax rebate within the period prescribed in law.
Your lordship may come to about the middle. However, the tribunal, without reference to the statutory provisions, proceeds on the assumption that allowing input tax is a statutory promise. This, my lord, I opened with this. It is not a statutory promise.
Concession.
It is a concession that I give. Made to the dealer buying the goods from the registered dealer by paying the tax mentioned in the tax invoice. There is nothing in law stipulating that if input tax is not claimed during the month succeeding the month in which purchase is affected, the dealer would forfeit his claim to input tax. In coming to the said conclusion, the tribunal has not applied its mind to subsection 3 of section 10, which is the provision which determines the net tax payable by a registered dealer in respect of each tax period in arriving at tax liability, the amount of tax. Yes.
If the assessee is not putting forth a claim for input tax deduction in the
Yes.
return.
In the return, precisely, lords. His right to claim input deduction is lost.
He cannot for the first time in the returns filed in put forth a claim for input tax deduction. The return was not related tax period during which the input tax was paid. That view of the matter. So it speaks of limitation, it speaks of requirement of making a claim in the return itself and then in contention. Yes. He also banks upon a coordinate bench decision in Centum Industries Private Limited. ILR 2015 Karnataka 57, paragraphs 11 and 14, to the effect that the claim for input tax concession can be entertained only if it is made within the statutory period of limitation, and further such a claim is made in the return itself and not otherwise. Okay.
Not the same proposition is found in infinite builders, my lord. Pass, but court of. Your lordships may be kind enough to come straight away to para 41.
Para
41,
page number
32 minutes.
scheme of the act.
The scheme of the act does indicate that a dealer virtually stands in the position of the state for the purpose of claiming credit to input tax. My lords, here, one, it is self-assessment. B, the collection of tax and payment is also through the selling dealer. The scheme of the act does indicate that a dealer virtually stands in the position of the state for the purpose of claiming credit to input tax from the output tax. When once an assessee has deducted the amount of input tax on the output tax, the remainder, which is the net tax, is bound to be paid by the dealer as the assessee is entitled to retain the tax.
Enabled to retain the tax.
Enabled to retain the tax he has himself paid earlier to his selling registered dealer. It is in this background the Act has provided for certain statutory and mandatory requirement as is found in sections 10 and 35 of the Act. The manner of claiming input tax, rebate or credit is therefore regulated by statutory provisions. The requirements are that the assessee who filed the returns at the first instance for claiming any input tax, rebate or deduction should disclose the same in returns filed with full particulars of registered dealer from whom purchases are affected by the assessee. Dealers' names are to be furnished along with return, and proof of payment of tax in the form of invoices issued by the selling dealer should accompany the same. In the present case, it is not in dispute, etc., etc. My lords, and therefore, finally,
Can we return, reassemble after 5 minutes?
yes, one submission, my lord. I'm originally arguing for admission, but I'm prepared to have this finally heard. I have no
Ready for argument on
Yes.
hearing itself?
Yes, yes.
I have no difference.
ಇಷ್ಟೇ ಹತ್ರ ಬೇಡ ನಂಗೆ ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡ್ತಾರೆ ಅಲ್ಲ ಇಷ್ಟೇ ಹತ್ರ ಬೇಡ ಇನ್ನೂ ಮುಂದೆ ಲಾಸ್ಟ್ ತೊಳಿ ಹಾ ಸಾಕು ಹೇಳಿ ವಿಲ್ ರೀಸೆಂಬ್ಲಿ.
Yes, fine.
ಪ್ಯಾರಾ 41 ಅಲ್ಲ?
Para 40. I was arguing for admission. If I ever wants to hear it, finally, I think we put in this. It is the case.
If at all anything because of. Yes, even with monetary limit zero. Only interest cannot come under monetary. What is the demand?
ಸರ್ ಬುಕ್ ಕೂಡ ಕೇಳಿದ್ರಲ್ಲ ಒಂದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ಗ ಮತ್ತೆ ಹೈಕೋರ್ಟ್ಗಲ್ಲ.
ನಂಬರ್ ಕೊಟ್ರೆ ಆಯ್ತಲ್ಲ ನಂಬರ್ Income by way of fraud. That is why it said, if you read the three, clause 5, 6, and 7. So this will come under 6.
Shankar.
My lord, seat number 30 and 33,
Uh,
both of us have to do some more verification of the monitor limits and some date.
33 na?
30 and 33. my lord.
Next week ಹಾಕೋಬೋದಾ?
Following week, my friend has some inconvenience.
Week after next ಹಾಕೊಳ್ಳಿ. Thanks.
My lords, in serial number 29,
29 is yet to reach.
all right, my lord.
Yes. Yes, we had some orders to sign. Therefore, we took more time. Yes.
Your lordship saw judgment 2013, my lord, para 41 I was relying.
41. Justice Shailendra Kumar's judgment.
The next judgment, my lord, is another judgment of this honorable court, coordinate bench in Nandi Constructions, Court of State. A remarkable remarkable development in this judgment, my lord, is that the principle that your lordship saw in Infinite Builders as well as in Centum. Now the Honorable High Court says principle is not limited to input tax credit alone. Return is paramount for any nature of rebate, concession, etc., etc.
For everything, it should be like that. Must be in the return itself.
Yes.
Paragraph.
Yeah. Your lordships may see that at paragraph 6, the discussion starts. Here, the issue involved was land cost.
So Centum was considered in.
Centum was considered, Infinite was also considered. Paragraph 6, my lord, short judgment. The main issue to be decided by this court is as to whether the petitioner can be granted benefit over and above what has been claimed in the returns filed by the assessee for the relevant tax periods. Admittedly, the claim of the petitioner in his returns filed for the relevant tax periods was at 45% towards land cost, though the assessing officer allowed only 40%. In the first appellate authority granted the benefit of 45% towards land cost. Question now to be decided is whether unless a claim is made by the assessee in its return and without the same being revised or modified by filing a revised return, any benefit beyond the benefit claimed in the return can be considered and allowed by the authorities. In our view, the answer would be a clear no. Then, my lords, after giving the clear no answer, the paragraph discusses infinite builders, Shailendra Kumar Justice's judgment, which I just read. Then 8 says,
Centum.
Kindly come to paragraph 9. We have no reason to differ with the opinion of the two division benches. Learned counsel for the petitioner has submitted that the question in the aforesaid cases was regarding grant of input tax rebate. Although this question doesn't arise, I am emphasizing it because of the primacy of the returns. That is my submission. Learned counsel for the petitioner has submitted that the question in the aforesaid cases was regarding grant of input tax rebate at his deduction. Whereas in the present case, according to the petitioner, his claim is exclusion of land cost. And as one
We are unable to accept that sentence.
we are unable to accept such submission made by the learned counsel for the petitioner as nothing more than what is claimed by the assessee in its return can be given by the authorities. In fact, my lord, this operates as an injunction against me. If I want to give also, I cannot give one now that the High Court has said so. The Act provides for filing a revised return under 35(4) of the Karnataka VAT Act. If assessee fails to avail of the benefit of filing revised return, then it is only the return which is filed, which has to be considered by the assessing officer or other authorities, and nothing more than what is claimed in the return that can be granted by the authorities in favor of the assessee. For the foregoing reasons, we answer the questions.
So, ಐಹಿಕ ಪಾರಮಾರ್ಥಿಕ ಎಲ್ಲ ರಿಟರ್ನ್ ನಿಂದನೇ ಹುಟ್ಟಬೇಕು.
My lords, my submission is return, and Honorable High Court says so. Return is the assessment. You are granted all the freedom in the world. Return is the assessment, self-assessment. Otherwise, we go back to
Could have revised it.
You could have revised it. Otherwise, we go back to Inspector Raj, Police Raj, which is not possible in today's economy.
Lot of discretion would lie with the authorities, which runs counter
And
to rule of
paperwork,
law.
everybody, we will all, instead of attending the High Court, we'll all be standing before the tribunal or some appellate authority.
Yes.
My lords, one more judgment of the Supreme Court before I go to in ALD Automotive.
How various other high courts have viewed this point.
I will come to it, my lord. In particular, my lord, the Andhra Pradesh High Court.
It's only comparative jurisprudence.
Andhra
They
Pradesh,
do not mind because we have our judgments, is our version.
Andhra Pradesh High Court, my lord, does me a favor by encapsulating all the law on the point. Then the Honorable Division Bench says this relates to input tax credit. The tax regime in the country is more or less the same. So what is held with respect to one statute will apply
Applies to other statute also.
2023, my lords. I'll go to that.
This is a ALD automotive.
ALD Automotive. There is also a judgment of the Division Bench of the Madras High Court in Justice Vineet Kothari's judgment. I'll, if need be, in reply, I'll bring that, my lord. I now recollected. That is, it's same principle, my lord.
Paragraph.
Your lordships may kindly come to paragraph 19. There, my lord, there was also a constitutional challenge.
The bearer bonds case.
Yes, my lord. Your lordships may then come to paragraph 21. The discussion starts with.
Here we have noticed that input tax rate.
Yes. Lords, thereafter, the judgment. My lords, in paragraph 23. Section 19(6) is extracted. Then paragraph 24 goes on whether there is inconsistency or repugnancy.
Our act only.
No, my lords, different acts. But para 26, no, my apologies. Para, the Karnataka is dealt with.
Karnataka is dealt with in
Para 36, my lord.
36.
Para 36.
Occasion to consider Karnataka.
Yes.
Agro.
Then after considering all this, the court comes again to Jayam, which I cited in 37. And then, my lords, after citing Jayam in 37, 38, 39, para 40 may be taken, my lords.
Issues 3 and 4.
Issues 3 and 4. The alternative submission pressed by the learned counsel for the appellant was that 1911 cannot be held to be mandatory, and it is only a directory provision, non-compliance with which cannot be.
What was that 1911?
My lords, again, time limit as well as furnishing of documents, my lord. 1911 is extracted, my lords. My lords, on para 23, it is extracted.
Para 18,
18,
page 235.
1911.
1911. In
1911
case
is.
the registered dealer fails to claim input tax credit in respect of any transaction of such month, he shall make the claim before the end of the financial, before 90 days from the date of purchase, whichever is later.
I'm grateful.
Provision was challenged. Provision itself was challenged.
Provision was challenged and upheld.
Upheld. And then the question was whether it is mandatory or directory.
But that did not say it should be claimed in the return itself. That is not the text of the section.
My lords, the
fact that he should claim it within a particular period shows that it need not be in the first return at all. Your answer is file revised return and claim it.
Yes, and I am on the principle that in the manner that it is provided, my lord.
If the manner is prescribed,
Is
you
the
can't transcend that one.
In no fast and loose transgression is provided for. A particular statute may say by filing a form, by giving a letter, by giving an application, where it says return and time limit for that return is also prescribed, that becomes the manner. When I come to 41, my lords, again, returns are discussed. Para 40. The alternative submission pressed by the learned counsel for the appellant is that section 1911 cannot be held to be mandatory, and it is only a directory provision, non-compliance of with which cannot be ground of denial of input tax credit to the appellant. Conditions under which input tax credit is to be given are all enumerated in 19 as noticed above. Condition under which the concession and rebate is always to be strictly construed. In event it is accepted that there is no time period for claiming input tax credit as contained in 1911, the provision becomes too flexible and gives rise to large number of difficulties, including difficulty in verification of claim of input credit. Taxing statutes contain self-contained scheme of levy, computation, and collection of tax. The time under which a return is to be filed for the purpose of assessment of the tax cannot be dependent on the will of the dealer. the use of the word shall in section 1911 does not,
mandate.
section 1911 in fact gives additional time.
Any other, except that the submission of input claimed cannot be beyond the time prescribed. It was more on limitation. But you say whatever applies to limitation applies to claiming also in the.
Because there is a time limit for the return itself. Return, revised return, it is a scheme, it is the manner is prescribed.
So literal interpretation.
Literal interpretation.
ಅಲ್ಲ ಕನ್ನಡದಲ್ಲಿ ಸುಂಕದವರ ಮುಂದೆ ಏನೋ ಕೇಳ್ಕೊಂಡಂಗೆ ಸುಂಕದವರ ಮುಂದೆ ಹತ್ಕೊಂಡಂಗೆ something like that. He will not show mercy at all. Filing of returns.
Yes, which pertains, which relates to
Tamil Nadu.
Tamil Nadu, the erstwhile Tamil Nadu VAT Act. This your lordship saw the scheme is similar.
Same ಇದ್ದಂಗೆ ಇದೆ.
Same. Section 1911 thus allowed an extended period for input credit, which if not claimed in any month can be claimed before the end of the financial year or before 90 days from the date of purchase. The provision of 1911 is thus an additional benefit given to the dealer from claiming input in the extended period. The use of the word shall make the claim needs no other interpretation.
So my question is also wrong. The word shall there should be of required things which he is bound to do. That need not be. Last paragraph 43, my lords. Supreme Court answers that also. Anyway, Supreme Court has said that way. Then we have no other, we can't defy what Supreme Court has said is your version. But in that judgment, whether it should be claimed in return itself did not fall for consideration.
The scheme is that of the return, my lord.
No, they say
Yes,
the taxing law should be interpreted literally.
literally,
You go by what the letter of law says, not the spirit.
my lords. But even here, my lord, the if your lordships see, para 41. The court appears to say that you have the opportunity in the return, and then 43,
That's all.
43 says it is a further opportunity. Photos.
Whether that was not one of the points considered in Mafatlal Industries.
Mafatlal Industries, I have relied on it for question of unjust enrichment. I will look it up whether it.
I believe if you want to seek refund, it should be within particular period. And it should be in the prescribed form itself, vague memory.
It is there, my lord, because on the
vague memory.
because on refund I have relied on it. What happens is
That was a doctrine against unjust enrichment, Australian author, etc., etc. They refer
what
to.
happens there is, my lord, there is a again it becomes relevant. He says, I was not aware that I had a concessional rate. I did another matter before coordinate bench. I was not aware that I was liable to pay only 4%. I have paid at 12.5%. Now give it back to me. Then we say, but you have passed it on. He says, no, mine is a turnkey contract. Everything is included. Whether it is 12% or 4% makes no difference to my purchaser. He has agreed to pay this price. So there, my lord, I had invoked Mafatlal. That is,
But in English law,
my lords.
under the English law of contract, where money is paid in ignorance of law, a citizen cannot claim it back because ignorance of law is no excuse. You ought to have known the law. But this VV is not, it does not obtain in India. Because money paid in ignorance of law or fact, section 71, 72 of the contract, what is it? 72 of the Contract Act. So, Mafatlal said, if money is paid in ignorance of law, still it can be recovered. 71 or 72 of the Contract Act nalli ಇದೆ. I read it. A person to whom money has been paid or anything delivered by mistake or under coercion must repay or return it. This is interpreted in Mafatlal, saying that this mistake can be of laws. 69. Reimbursement of person paying money due by another in payment of which he is interested. A person who is interested in the payment of money which another is bound by law to pay and who therefore pays it. No, this is where suppose the landlord has to make the taxes to the corporation. Landlord does not pay. Then the tenant can make the payment. Otherwise, he may lose the tenancy itself if they put the property to sale, etc. Anyway, the courts have said that the mullah and especially Woodruff, Mullah, Amir Ali, they have said that in India that principle does not apply. And that is repeated in Mafatlal itself.
More so in tax matters because Article 265 protects the SSCs.
But because you cannot
Take any tax
recover
without
what is not
authority of-
authorized by law. That's what. They referred to that one also.
Correct.
I think it was Fali Nariman who argued that matter. I vaguely remember. Eh? 98, 97, 98. Excise law times 1997 perhaps. Mafatlal.
The Andhra Pradesh High Court judgment, my lord.
Yes.
Para (21) minutes.
The further argument.
The further argument of the petitioner that 16(4) of the AP GST CGST Act violates 419(1)G and 300A of the Constitution of India is concerned. Said argument has no vitality for the reason. Firstly, ITC is a mere concession rebate, but not a statutory or constitutional right, and therefore imposing conditions, including time limitation, for availing the said concession will not amount to violation of constitution or any statute. And secondly, as rightly argued by the Advocate General, the operative spheres of 16 and constitutional provisions under 14, 19, 1G and 300A are different, and hence infringement doesn't arise. Thus, by nature, ITC is a concession rebate by benefit, but not a statutory right, has been reiterated in a thicket of decisions. And then, my lord, Jayam is extracted. Then ALD automotive, which your lordships just saw, is extracted.
You know what is meant by concession? Suppose it's only a concession, you don't have right, therefore I will not return it to you.
Yes.
Can a welfare state say that? What is meant by concession? It's not a gratis.
There are cases, my lord, for example, under service law, where I'm providing housing to my personnel as a the courts have considered the various emoluments, benefits, concessions, etc. In a particular case, the payroll in accordance with the pay commission or seniority, etc. is tied up. In addition, in some circumstance, I may be able to provide housing benefit or some medical facility. Courts have said, look, if I do not meet what is you are entitled to as a right, it is agitable. Supposing I'm not able to provide you housing because there is a physical limitation or for some other reason, it is concession, not justiciable. That is the distinction that the courts have drawn between concession and. There are judgments, my lord, in service law, it is there. And the same is therefore brought over here, a benefit, a concession. Had it not been for this particular scheme, there is nothing inherent in you to be able to stay in my quarters. My lords, the various judgments are extracted, including one and in USA agency's case. Then the two Supreme Court judgments I relied on, then USA agency's Madras High Court, Willowwood of the Gujarat High Court.
MK Agro of Karnataka.
MK Agro is cited in this one itself, ALD Automotive Methods.
So this is Bible on the.
Yes, and it is also fairly recent manner, 2023. Para 25. Though the above decisions deal with ITC claim relating to this concerned state laws, however, since concept of ITC is one and the same, these decisions will apply equally to the case, equally apply to the case on hand. Thus, it is clear that ITC being a concession benefit rebate, the legislature is within its competency to impose certain conditions, including time prescription for availing such right, and same cannot be challenged on the ground of constitutional principle. As rightly argued by Advocate General, operative spheres of those so-and-so is different. In order to establish so-and-so. Thus, on a we hold point number 1. Time limit prescribed for claiming ITC under 16.4 of the is not violative. Section 16.2 of APGST, CGST has no overriding effect. Both are contradictory. They will operate independently. Mere acceptance will not exonerate the delay. There, my lord, on payment of 10,000 rupees, they had accepted a certain delayed return under that act. And therefore, my lord, here the constitutional validity was upheld. I am relying on this for para 25, where it says that I impose conditions, you cannot find fault with those conditions.
You comply with condition and get that concession.
Get that concession.
So concession grantable on compliance of condition is your submission.
Yes. Kindly see, my lords. The impugned order at page 55.
Paragraph
61, my lords, at page,
it can be inferred from the above.
It can be inferred from the above deliberations that the provisions of the Act has not prescribed any time limit for making a claim of additional input tax credit as per the provisions of Section 14 of the Act. Therefore, it can be deducted in the above circumstances that the claim for eligible input tax credit is an indefeasible right which is available to the dealer registered under the Act without any limit of time for claiming such input tax credit. My lord, in my respectful submission, this judgment fails when it says indefeasible right
And about limitation now.
without limitation. At this point of discussion, it becomes relevant and appropriate to note that section 14 of the Act provides for a special rebating scheme where deduction of input tax should be allowed on purchase of goods that are dispatched outside the states other than as a direct result of sale and purchase made during the course of interstate trade, 4%, etc. In the incident case of the appellant, government has prescribed lower rate by way of, therefore, my lords, then he says this is on the rate. What is the excess? Then your lordships may come kindly to paragraph 69.
Therefore, for the period.
Yes. Therefore, for the period
From
from April 2008 to May 2008, it goes without saying that even though the appellant has not claimed the deduction of input tax credit at one rate of 1% from local purchases of input taxable at the rate of 4% as envisaged in provisions of section 14 in the monthly return of turnover or form 100, appellant is eligible. Because he treats that it's an indefeasible right. Then he repeats the same thing for the next period, June 2008 to March 2009, the rates different.
Yes.
Also, the order of the SMR authority in revising the order of the assessing authority on the pretext that the appellant is not eligible for deduction of input tax credit at 1% for the period of April 2008 to March 2000, also not eligible for input tax credit or so and so on local purchases as envisaged with the provisions of
So
section.
it proceeds according to you on two legal infirmities. Number one, it treats the claim not as a matter of concession, but as a matter of right. Number one. Number two, he says that there is no limitation for making that claim at all.
Yes.
These two.
And the two are interlinked.
No, whether he made the claim in the return or not, on that where is the finding?
No, please, my lord, 71.
Huh?
Kindly see. Kindly see on the top of page 50, at the bottom of page 56. I don't think that is on dispute, my lord.
56.
Bottom of page 56, para 69. Therefore, for the period from the April 2008 to May 2008, it goes without saying, even though appellant had not claimed deduction of input tax credit, so and so,
No, he's
in the monthly return.
Huh?
In the monthly return.
Where is that?
My lords, about 4 lines on the bottom, page 50.
In the monthly return.
In the monthly return. Same language, my lords, is para 70, third line from the bottom. In the monthly return. Para 71. The fourth line from the bottom. On the grounds that the aforesaid deduction is not claimed in the monthly return of turnover in form VAT 100 is therefore incorrect, improper, bad in law, needs to be set aside. The moment he proceeds on the assumption that it is an indefeasible right, my lord, he comes to the wrong conclusion. Originally, I was planning to say if he proceeds the horse of the judgments of this honorable court, that constitutes a sufficient question of law. But I'm obliged, my lords have given me the opportunity to argue it.
Yeah, may I please? My lord, the tribunal has followed a division bench judgment of this honorable court in my own case. It's not as if the tribunal has decided this on its own. If my lords kindly see, before I take this, your lordship to the scheme of the act and all that, I'll just point out, which my learned friend did not bring it to your lordship's notice. Therefore, I thought first I should bring that to your lordship's notice. Paragraph impugned order, since your lordships are on the impugned order now. Kindly see page 47. Para 52. My lords have that?
Yes. Messrs. Tractor.
That the learned counsel has filed a copy of the judgment of the Honorable High Court in the own case of the appellant so-and-so, dated so-and-so for perusal of the relevant paras of the passage of the above judgment delivered by the Honorable High Court dated so-and-so. May I read that judgment, my lord, which has been extracted just to.
Only relevant, in health day. What
It
does it
basically
say?
says, in my own case, on identical facts, this honorable court has said that even though I have not claimed it in the written, I can claim it subsequently because this is not a case of self-assessment as my learned friends have put. It's a case of reassessment under 39. The assessing officer can grant me a benefit which has been provided under the act, even if I have not claimed it in the written, that there are any number of judgments. I'll come to that. I'm only to answer the point, because my learned friend concluded by saying that the tribunal has not looked into any judgments of this honorable court. All that I am saying is the tribunal has followed a decision of this honorable court
Where
in
is
my
that-
own.
Where is it said? Even if you are not claimed, it should be given in that judgment.
What my learned friend just read and said that is in TAFE, my lord, in the SC's own case.
Yes.
I'll just pass on the. So the STRP before your lordships is for the assessment year 2008-9. 2007-8 had come up before this honorable court.
That paragraph, it
Yes.
need not be claimed in a return at all.
Yes.
Where is that?
So if my lords kindly see paragraph 3, I'll just point out what all has been considered by this honorable court. I have kindly see page 6, para 3. The department relied on infinite builders and centum, which my learned friend also relied on before your lordships.
Correct.
Then we relied on Giridhari Parasmal, a decision of this honorable court, which says that even though I have not claimed it in the written, when the assessing officer is taking up an assessment, he has to give me a benefit which is otherwise provided under the act. Then I have relied on Daichi Supreme Court, which says that input tax credit, VAT credit, which is akin to input tax credit, is an indefeasible right. Supreme Court says that. And the other decisions of this honorable court, taking the view that input tax is an indefeasible right. Kindly see paragraph 8. Para 10. Page 16. My lords have that?
Yes.
In the instant case, the SSC has claimed the benefit of input tax credit at the rate of 4%. However, subsequently, a claim was made for additional input tax credit at the rate of 1% on account of an error in disallowing input tax credit at the rate of 4% as specified in section 14 of the Act instead of 3% as specified in the notification dated 30/3/2007. No time limit has been prescribed under the provisions of the Act for making a claim for additional input tax credit. Therefore, the claim for eligible input tax credit is an indefeasible right which is available to the dealer under the Act without any limitation of time for claiming such credit. It is pertinent to note that section 14 of the Act provides for special rebating scheme where the deduction of input tax shall be allowed on purchase of goods that are dispatched outside the state other than as a direct result of sale and purchase made during the course of interstate trade or commerce to the extent of input tax credit charge higher than 4% or any lower rate as may be notified by the government. In the instant case, the government has prescribed the lower rate of 3% by notification dated so-and-so, and therefore the aforesaid rate was applicable for the tax period 1/4/2007 to 31/3/2008.
No, here we had filed the revised return.
No. I have not filed the revised return. I have claimed it during the course of assessment and the assessing officer granted it. Thereafter, a suo motu revision was done.
Slowly.
Yes,
You made the claim, not in the return.
not in the return.
On that where the court has said.
The next, I'm just reading the next sentence. Therefore, the petitioner cannot be deprived of the aforesaid statutory benefit and section 35 of the Act, which deals with returns, does not curtail the entitlement of the dealer to such statutory benefit to it if such return is not filed within the time prescribed therein.
It is on limitation.
I have not filed this thing in this case. In this,
Sir, this discussion is on limitation.
no.
Question is,
Huh.
even if it is not claimed in the return, still input tax concession should be granted. Adellide.
That's exactly what the High Court has said. If my lords kindly see the facts. Question, my lords may kindly see the question also.
Which where?
Page 3. Because that was my appeal. In fact, KAT,
No,
Held against
on
me.
how it is treated.
Yes.
That you have to answer that
yes,
question.
I'll deal with it. My lords may kindly see the question at page 3, para 4. Holding that the petitioner is disentitled from claiming input tax credit that it is eligible to avail under the provisions.
One second.
Yes.
Page 3, para 4. Page 3.
The fourth question, holding that the petitioner is disentitled from claiming input tax credit that it is eligible to avail under the provisions of section 14, read with notification dated so and so, merely because the petitioner had inadvertently understated its input tax credit eligibility in its returns filed for the relevant tax period and has failed to rectify the bona fide error in the revised returns filed within the prescribed time period.
Bona fide error.
There you had filed the return, revised return you had filed.
No. I have not claimed it in the revised return is what the question is. I have not claimed it in the original return. I have not claimed it in the revised return. Whether I can claim it was the question. And that's what has been answered. In any case, I'll come back to this judgment because this judgment considers various other judgments, which my learned friend has not cited.
No,
Of
which is
this honorable
cited,
court.
Of course.
Yes. So I'll start from the basics. Let's go back to the basics. Kindly see the scheme of the act first. The decisions cited by my learned friend on concession, that input tax is a concession, are in the context of challenge to those provisions under the TN VAT Act and the AP VAT Act, where the state wanted to impose certain restrictions or take away certain benefit. In that context, the Supreme Court and the AP High Court said, the state has the power to give a concession or to take it back. It is in that context, they said, it is a concession. But my lords may kindly see, once a concession is given under the statute,
Becomes right.
it becomes a right. And therefore, the Supreme Court in Daiichi said, once input tax credit has been provided, SENVAT credit has been provided for under the Act, it becomes an indivisible right. Under 10.3, which my learned friend read,
Which is that judgment? Just give that.
Daiichi.
Provided he complies with. Not willing.
The decisions, if my lords kindly see those two Supreme Court judgments, which my learned friend relied on, and the AP High Court, they were
There-
challenged to the constitutional validity of the provisions imposing a restriction.
In other words, it is for the legislature to give that as by way of concession or otherwise.
Or not.
If
And it
legislature,
can impose, while giving that concession, it can impose certain conditions.
if
In that context, the Supreme Court said it's a concession, therefore it cannot be said to be violative of Article 14 or 19 is what the Supreme Court says. But kindly see Daiichi, which is a larger bench decision, 1999-7 SEC, paragraph 17. This is in the context of central excise SENVAT credit, which is akin to input tax credit under the VAT Act. Paragraph.
Yes, the condition is the condition of filing return.
I'll come to that.
I am not joining issue at all. Provided he meets my condition that it has to be claimed in the return.
that means claim should be made in the return itself.
Paragraph 18, my lord.
17 reproduces section 57A.
Yes, kindly come to paragraph 18.
It is clear from these rules.
It is clear from these rules, as we read them, that a manufacturer obtains credit for the excise duty paid on raw material to be used by him in the production of an excisable product, immediately it makes the requisite declaration and obtains an acknowledgement thereof. It is entitled to use the credit at any time thereafter when making payment of excise duty on the excisable product. There is no provision in the rules which provides for a reversal of the credit by the excise authorities, except where it has been illegally or irregularly taken, in which event it stands cancelled or if utilized has to be paid for. We are here really concerned with credit which has been taken, which has been validly taken, and its benefit is available to the manufacturer without any limitation in time.
For the credit
And-
is indefeasible.
Yes, the credit is therefore indefeasible. It should also be noted that there is no correlation with the raw material and the final product. That is to say, it is not as if the credit can be taken only on a final product that is manufactured out of the particular raw material to which the credit is related. The credit may be taken against the excise. Now, why they say once, that's why, my lords, when my learned friend read 10.3, your lordships asked a question, where does 10.3 say that it has to be claimed in the return?
No, rule says.
I'll come to the rules. Tail cannot wag the dog. If the provision says you can claim it, rule cannot. Rules are machinery provisions. Return filing is a machinery provision. 10.3 is a substantive provision which gives me a benefit of input tax credit. And the scheme of the act, therefore, I wanted to start with the scheme of the act. Kindly see the VAT Act, the scheme, objects and reasons first. Let's start from there, Mother.
Section.
The objects and scheme of the act itself on the first page before the section 1. What is the concept of VAT? Why I am saying input tax credit is an indefeasible right? Why the Supreme Court said? Let's see why it has said. Statement of objects and reasons, my lord. It
An
is
act of
considered
provision-
necessary to introduce value-added tax to replace the present sales tax system in line with the national consensus for bringing in reforms in commodity taxation. The new legislation provides for the following, namely, widens the tax base by levying tax on sale of goods at every point of sale. Because earlier, my lord, as your lordships were aware, under sales tax, it was a multi-point tax. At every point.
Every sale
there-
point tax used to be levied.
At every point of sale, tax used to be levied. So to get over that, this act was brought in. Makes the levy of tax transparent and removes cascading effect. Now, how do you remove that cascading effect? By giving me input tax credit for the purchase that I have made.
Item 5.
Then four also, my lords mercy. Provides for set off of all tax paid at the earlier points in respect of goods sold. That would include tax paid defined as input tax on capital goods, raw materials, components, and other inputs, including consumables with some restrictions, and packing materials that are used in the resale or manufacture or processing of goods being sold against tax payable defined as output tax. At any point, the set-off scheme being called the input rebating. Tax paid on inputs purchased within the state is to be provided rebated against the goods sold within the state in the course of service. So the scheme of the act itself is such that it wants to remove the multi-point levy which earlier existed. It wanted to remove the cascading effect. Now, how do you remove that?
Ultimately,
Yes,
in the thicket of these decisions, matter boils down to
correct.
whether the prescription under Rule 38 A is mandated in the sense one who claims input tax credit has to make the claim in the return itself or not.
Correct. I'll come
Whether
to
you
that.
Call it concession or not. Only that will be the focal
Correct.
point of our this one.
Correct.
Whether that rule is discussed by Justice Aradesab in your judgment.
No, it's not discussed. Rule is not discussed, but I'll come to that. Why the rule has no relevance.
Afterwards.
Yes, after lunch.
But lot of learning we did.
Serial number 44, my lords, for 1 week.
44 ಯಾವ ಇಯರ್ ಅದು?
My lords, 19,
19.
please.
ನೋಡೋಣ ಇದು ಬೇಗ ಮುಗೀತು ಮತ್ತೆ ನಾವು ಬೇಕಲ್ಲ.
Your lordship, personal inconvenience, my lords, kindly. have the
2019 ಅದು.
Please,
This was posted earlier also.
please.
This even I'm also not keeping well much. My throat has gone.
You're not well. You ate ghee or what?
It is
Next week.
Lordship, interim order may extend.
Interim order to continue. ಇದು week after next ಕರೆಯೋಣ?
Please.
Week after.
Your Lordship, serial number 14, passed over matter.
Ah.
Your Lordship, in that matter, we are exploring the possibilities of the Vivad Se Vishwas scheme, Your Lordship.
14.
14, Your Lordship.
You want time?
2 weeks' time may be done.
At the request of assessee.
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 Serial number 6.
Mr. Will Gold is waiting for whom?
Happen to be here, Madam Sati. Sushal appears to be mentioning a matter I'm appearing, but
Serial number 43, my lords.
43.
Week after next, my lords. Even Mr. Raviraj has some difficulties in the afternoon, my lords.
Week after next.
Serial number 6, my lords. The matter has been passed over filing better affidavit. I filed a better affidavit, lords. Needful has been done.
Needful is done?
Yes, my lords.
No, needful is stated to have been done by filing better affidavit. Very. Okay.
I'll tell you how I want to proceed. You will tell me what all is there. I've read, now I will have to read 10(3). And rule cannot override rule cannot impose something which the provision doesn't have. Have to.
35 section 1.
Nepal is also a case not claimed in the return.
No.
Hmm? Issue is different. Hmm. K bond. What are we keeping? So say that the rule cannot override. Wipro are we getting? What is there in Wipro? Correct. Are we keeping that? I'm asking. Other than Girdal. Correct. One more latest. Girdal is some 1969 also. Where is it said exactly what we're not claimed it in that? I think in that year, we claimed it less. We claimed it in the return. We claimed it less, we claimed more.
1% differential, we have not claimed it.
Percent
Additionally,
differential.
we claimed it during assessment that comes in para 2 below the facts. Similar to this year.
No, here we have not claimed it at all. No?
The differential was not claimed. So far as 12%, 12.5% dues are concerned, we claim.
Correct. On 4% goods, we have not claimed at all.
I don't think we have claimed. That's how at least I understand.
I have not made such claim. You get your bags and come. We'll have to leave from here directly. Get everything. And Swami Dayaji. Point out MFAR and stay. MFAR and stayed by Supreme Court should be point out. I'm sorry. No, to say that MFAR, that decision, the view has been stayed by the Supreme Court. Whereas this view that it is an indefeasible right has been accepted by the Supreme Court. Because all kinds of nonsense that lady says, that's a different matter. Nagaratna was in BML, in the last para, what is the meaning of last para when she says we don't agree?
in 16 itself, in the input tax credit section itself, say notwithstanding anything, no registered person shall be entitled to the credit in respect of supply unless is all of this and files a return. Is furnished as a return number 13. And the details of this one also. Okay. This is
No, that is, if you are not furnishing the return at all, let us say you furnish a return and
But
don't
don't
claim
claim
it, that doesn't apply. It is, see, somebody has to understand these provisions. Where is it said in return 35 or rule 38 that if you don't claim it in the return, you will not get it? Where does it say? Where do you get that?
he is reading that shall word in 38.
Shall file the return
Correct, correct,
containing
correct.
these details.
Correct.
Shall is for filing a return.
Yeah.
You have an obligation to file the return. Filing a return will not contain all the details.
General matters. General miscellaneous.
rather than an exception. In other words, if you do that necessarily required, firstly, I'm not and then a version available. This can be found. You do that in this case. months return, that's a different matter. And the argument was they should have filed a revised return and only then.
Yes.
My lords, I had just read the statement of objects and reasons.
Yes.
Of the act.
Scheme you wanted to tell
Scheme
us.
I have read. Kindly see the definition of input and output tax. The definition of input tax,
Section,
section 2, subsection 19 is the definition of input. Subsection 20 is definition of input tax. Section 2, subsection 19.
input.
Input means any goods, including capital goods purchased by a dealer in the course of his business for resale or for use in the manufacture or processing or packing or storing of other goods or any other use in business. Then input tax means has the meaning assigned to it under section 10. Then output tax has the meaning assigned to it under section 10. Now kindly come to section 10. Basically, section 10, my lord, is computation of my tax liability itself. If my lords kindly come to section 10.
Output tax, input
Output
tax,
tax, input tax and net tax. Subsection 1 says output tax in relation to any registered dealer means the tax payable under this act in respect of any taxable sale of goods made by that dealer in course of his business and includes tax payable by a commission agent in respect of taxable sales of goods made on behalf of such dealer subject to issue of prescribed declaration by such agent. Basically, my lord, if I make a sale of goods, I'm liable to pay output tax on it. That's what subsection 1 says. Now kindly see subsection 2. Subject to input tax restrictions specified in section 11, which my learned friend already read, 12, 14, 17 and 18. Input tax in relation to any registered dealer means the tax collected or payable under this act on the sale to him of any goods for use in the course of his business and includes the tax on the sale of goods to his agent who purchases such goods on his behalf, subject to the manner as may be prescribed to claim the input tax in such cases.
So
input
manner,
tax
subject to the manner
subject to the manner as may be prescribed to claim input tax in such cases. Correct. So input tax basically means if I make certain purchases for use of those goods for resale or for manufacturing,
correct,
then the taxes that I pay on those purchases is the input tax credit. Now, how is my tax liability determined is in subsection 3. Now kindly come to subsection 3. Subject to input tax restrictions specified in sections 11, 12, 14, 17, 18 and 19, the net tax payable by registered dealer in respect of each tax period shall be the amount of output tax payable by him in that period less
the input tax
deductible by him as may be prescribed in that period and shall be accounted for in accordance
and
with
relatable to goods purchased
by him
during the period immediately preceding the amendment.
They have omitted it with effect from 1st April 2015.
Okay. ಹೆಂಗ್ ಓದ್ಬೇಕೀಗಿದ್ದ?
So basically subsection 1 defines output tax, subsection 2 defines input tax, subsection 3 says my liability will be output tax minus input tax. This provision basically is computation of my tax liability. Therefore, it is a very substantive provision. This is not a machinery provision. Now, kindly see the returns. Now, the entire argument of the department is if I don't claim this input tax in the return, now, my lords have seen section 10. Section 10 doesn't say that I have to claim it in the return. Section 10 as it is doesn't say. My lords have seen that.
1 second.
Yes.
Slowly.
Yes.
10 says.
Yes.
Subject to the manner as may be prescribed.
Subject to the manner as may be prescribed to claim input tax. To claim input tax in such cases, in cases where agent, what it refers to the earlier, it can't be read in isolation. If my lords kindly see.
In such cases means?
Where the agent has made the purchases. Let us read it once again very slowly. subject to input tax restrictions specified in sections 11, 12, 14, 17, and 18, input tax in relation to any registered dealer means the tax collected or payable under this act on the sale to him of any goods for use in the course of his business, and includes the tax on the sale of goods to his agent who purchases such goods on his behalf, subject to the manner as may be prescribed to claim input tax in such cases. Such cases obviously is reference to something that is said prior.
Agent's case.
Agent's case, aste. Not in the manner prescribed elsewhere in the act. It only refers to if the sale purchase is by the agent, how do you claim it? That has been prescribed under the rules that we are not concerned with.
Three may be read. Three.
Then let us
Subject to
read 3.
input tax restriction.
Correct. Subject to input tax restrictions specified in. So input tax restrictions are specified under the Act. 11, 12, 14, 17, 18, and 19 are provisions which deal with input tax restriction. None of these provisions say that if I don't claim in the return, I'm not entitled for input tax credit. That's one thing.
Let us read it.
Yes.
The
Subject to
net
input tax restrictions specified in sections 11, 12, 14, 17, 18, and 19, the net tax payable by a registered dealer in respect of each tax period shall be the amount of output tax payable by him in that period less the
input tax
deductible by him as may be prescribed in that period. As may be prescribed is, how do I claim input tax credit? There are rules for that. I'll take your lordships to the rules, which is not rule 20, the 38, which my learned friend read. That rule is pertaining to returns. I'll come to the rules. Shall be accounted for in accordance with the provisions of this act. It has to be accounted. That's all the provision says. The provision doesn't say, one thing your lordships may note, this provision doesn't say that if I don't claim that input tax, let us
in the return.
We will go to the rules also, the prescribed rules also. Whether the prescribed rules also they say
what you say is the text of subsections 2 and 3 of section 11 does not give
Section
scope
10.
for the 10.
Yes.
Does not give scope for the argument that to get input tax concession, if at all it is a concession, it need not be claimed in the return itself.
That it should be claimed in the return itself, the provision doesn't say.
That's what.
In fact, GST Act says unless you file a return, the new act which has replaced this act, unless you file the return, you cannot claim. That's GST Act specifically says that. If my lords kindly see, I'll just point out, although it may not be, it may only support my argument.
May not support because legislative bodies are different.
No. GST Act, there's a KGST Act also.
Karnataka only.
Yes.
That itself says that.
Yes.
Okay. Got it.
Same provisions apply. CGST, KGST are virtually the provisions are the same. Because as your lordships know, GST is levied both by the center and the state. So there is a central GST Act and there is a Karnataka GST Act also.
With effect from 1/7/2017.
Yes.
1/4 or 1/7?
1/7.
1/7.
If my lords kindly take section 16. That section 16, yeah.
Learned senior advocate Mr. Surya Narayana submits that the text of subsections 2 and 3 of section 10 does not give scope for the argument that for claiming input tax concession, the claim should be in the very return itself. First off, he specifically interprets the last 2 lines of subsection 2 by saying that the expression manner as may be prescribed is referable to agents' cases and not to regular cases. First. He also submits that in view of text and effect of subsections 2 and 3, comma, the input tax credit cannot be termed as a concession at all, comma, it being a right consistent with the objects and regions of the act itself, which specifically mention that also. All.
I just want to refer to section 16 of the GST Act. Just to say that under GST Act, they say.
Support of this submission, he also draws our attention to section 16 of KGST Act,
KGST Act. CGST, KGST,
Act,
same provision.
which in so many words provides for claiming input tax credit only when such a claim is made in the return.
Only when a return itself, if return is not filed, you can't even claim it.
Only when the return is filed and not otherwise at all. Full stop. The KGST Act being a cognate statute made by the same legislature
and which repeals VAT Act. This act repeals VAT.
Repealing the 2003 Act, comma, the intent of the legislature can be ascertained by the variation in the terminology of the relevant provisions in the earlier Act and in the new Act.
Now, my lords, may kindly see section 16, subsection 2 of the KGST Act.
He stresses on the negative terminology enacted in subsection 2 of section 16, which is conspicuously absent under section 10 of 2003 Act.
And my lords, may kindly see subsection 2, clause D. Notwithstanding anything contained in the section, no registered person shall be entitled to the credit of input tax in respect of any supply of goods. Kindly see D. He has furnished the return under section 39, unless he has furnished the return under section 39. If return is not filed, then their claim for input tax credit is foregone.
Means claim is not made in the return antana?
Return. Not in the return. I'm saying they have imposed these restrictions while claiming input tax credit under section 16, which is absent in section 10. Section 10 doesn't provide for any restriction.
Slowly.
Even in a case where I don't file a return under the VAT Act.
Slowly.
Yes.
Slowly. What the revenue says is, you have, if you want input tax credit, you have to make the claim for that
in the return.
Itself.
Correct.
If you have not made
for that
in the origin,
yes,
in the return, you can file revised return also
and claim it
within the stipulated period
6 months
and claim it.
Yes.
This duty arises, or this prescription is under Rule 38 of this Act.
That's our argument.
Our argument.
Correct.
Ali, return should be filed ಅನ್ನುವಂತ requirement, filing of return, not filing of return, ಇಲ್ಲಾಕೆ ರಿಲೇಟ್ ಮಾಡ್ತಾ ಇದೀರಿ ಅಂತ ತಿಳಿತಾ ಇಲ್ಲ ನನಗೆ.
ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂದ್ರೆ ಸೆಕ್ಷನ್ 16 of the GST Act, unlike section 10 of the KVAT Act, imposes certain restrictions for claiming the input tax credit itself, which are absent under section 10. Section 10 is unconditional.
By going by text of rule section 16 of this new act.
Section 16 subsection 2 of this act, all that I'm saying is, if the legislature wanted to impose any restrictions, they have imposed restriction.
This language would have been found in section
Should have been
10
found
to
under section
3.
10 itself, or in fact, the legislature has imposed restrictions for claiming input tax credit by way of section 11, 12, 13, 14, 16, 17 and 18. Under those provisions also, there is no restriction that I cannot claim the input tax credit unless I file the return, unless I claim it in the return. That's what I'm trying to say. There are restrictions under various other provisions, but the restriction that I cannot claim that credit unless I claim it in the return is nowhere found under the KVAT Act. I'll come to the returns provisions also. And one more point, my lord, for your lordship's consideration. 10(2) and 3 say subject to restrictions under 11, 12. There can't be any more restrictions other than that. If the provision specifically says that you are entitled for input tax credit subject to restrictions under 11, 12, 13, 14, 16, 17 and 18, whatever, can you import something more than that?
Where is the rule making power?
I'll come to that.
Just show that.
Yes. I'll come to that. Now let us go to whether the return itself, whether the provision which deals with return itself says that I have to, unless I claim that input tax credit in the return.
Your version we have understood.
Yes.
But
35 nallu helalavu.
he also says that when the legislation itself has not made filing of claim of input tax credit in the return itself, rule cannot superadd such a requirement. More particularly when,
according to me, it does not, but even assuming it does, it cannot.
Once the provisions of sections 11, 12, 14, 17, 18 and 19 specify what would be the restrictions. First of all, other than legislative restrictions, no restriction can be read in the subordinate legislation, namely the Rule 38. First.
88(4), my lords.
80,
section 88(4).
Rule making power, I'll come to that. First, let us go to section 88. Section 88.
88 is
deals with power to make rules.
88.
Kindly, but first see section 35, then we'll go to, chronologically, let's go. Kindly see section 35, returns. Subject to subsections 2 to 4, every registered dealer and the central government, a state government, a statutory body and a local authority liable to pay tax collected under subsection 2 of section 9 shall furnish a return in such form and manner. Only it talks about only form and manner, including electronic methods, and shall pay the tax due on such return within 20 days or 15 days after the end of the preceding month or any other tax period as may be prescribed. So all that subsection 1 of section 35 says is that every registered dealer should file the return in the form and manner prescribed under the rules. That's all the provision says. It doesn't say, even this section doesn't say that if you don't claim anything in the return, you are entitled from claiming it forever. That's not what this provision says. Now kindly see section 88.
1 second.
Yes.
Next paragraph. He reads section 35(1) as being confined to filing of the return in the form and manner prescribed by the rules. And it does not say anything about claim being made for input tax credit.
Disentitlement of claim not being made in the,
In any event, it does not say unless the claim is made in the return itself, comma, the assessee is disentitled to any input tax concession.
while we are on section 35, my lord, subsection 4 says you can file a revised return within 6 months there anyway. The argument is if I should have made a revised return, otherwise I would not have claimed. Therefore, the timeline.
Return
those
format ಇದೆ no?
Format ಇದೆ.
ಅದರಲ್ಲಿ ಏನಾದ್ರು ಇದೆಯಾ?
ಇನ್ಪುಟ್ ಟ್ಯಾಕ್ಸ್ ಕ್ಲೈಮ್ ಮಾಡಬೇಕು. ಕಾಲಮ್ ಇದೆ.
ಫಾರ್ಮೆಟ್ ನಾಗಿದೆ.
ಕಾಲಮ್ ಇದೆ.
ಫಾರ್ಮೆಟ್ ಎಲ್ಲಿದೆ?
Form VAT 100 page, if my lords have the same book, there's a monthly return, there's an annual return. Now, one more thing, important point your lordship.
ಒಂದು ನಿಮಿಷ, ನಾವು ಬರೆಯೋಕ್ಕಿಂತ ಮೊದಲು ನಮ್ಗೆ ಉತ್ತರ ಕೊಡಿ.
Yes, yes.
ಆಮೇಲೆ ಮುಂದೆ ನಿಮ್ದಕ್ಕೆ ಹೋಗ್ತೀವಿ.
Yes, Form VAT 100 would be, I'm not sure in your lordship's book. In this book, it is page 240.
240. Form
VAT 100.
VAT 100. Right, 10.
Now, if my lords kindly see the form,
One second.
form only says how to compute the tax. Output tax payable, net tax payable. My lords will kind of find at 4, net tax payable.
4.3 is input tax credit.
ಹೌದು.
4.3.
ಹೌದು.
ಅಲ್ಲಿ ಬರ್ಕೊಂಬ. We notice from the statutory form VAT 100, which is prescribed for the return at paragraph 4.3 specifically mentions about input tax credit. While adjudging the net tax payable. ಅಲ್ಲಿ ರಿವೈಸ್ಡ್ ರಿಟರ್ನಿಗೆ ಏನಾದ್ರು ಪ್ರಾವಿಷನ್ ಇದೆಯೇನು? ಫಾರ್ಮೆಟ್ ಇದೆಯೇನು? ರಿವೈಸ್ಡ್ ರಿಟರ್ನಿಗೆ.
Revised return. Lordship may see. In form 100. 1.3 ತಾವು ನೋಡಿದ್ರೆ ಟೈಪ್ ಆಫ್ ರಿಟರ್ನ್ ಅಂತ ಅದರಲ್ಲೇ ನಾವು ಸ್ಟ್ರೈಕ್
Original corrected or revised ಇದರಲ್ಲೇ ಬಂದ್ಬಿಡ್ತು.
And my lords may kindly see form VAT 240 also. That's the annual return that is required to be filed.
240. Yeah. Correct. Form
VAT 240. It is not an annual return. Your lordships will see what it is. The word return does not appear. And it does not apply to all assessees.
What? Form VAT 240.
Yes.
Guidance points. Huh?
319 ಅಲ್ಲಿ ಬರುತ್ತೆ. Guidance points ಇಂದ ಮುಂಚೆನೆ ಬರುತ್ತೆ.
Form VAT 240 ಅಂತ ಇದೆಯಪ್ಪ ಇದರಲ್ಲಿ.
ಹೌದು. It is a chartered accountant certificate. Audited statement of accounts under section 31(4) of the KVAT Act. We'll go to 31(4). And the relevant
Audited statement of accounts under section 331(4).
ಹೌದು. Which is not a return.
audited the statement of accounts.
It is with respect to some assessees whose turnover is high.
Only for
And-
them it is compulsory.
And,
Like income tax audit that way.
and it is signed by a chartered accountant. Not by the assessee.
No, even item 2 of that format.
Provides
Input
for,
tax deduction claimed under section 10.
correct. That's all I'm saying. Whether
So
they-
claim can
they
be
call
made
it-
under section 10 itself.
Ah.
Claim of input tax made under section 10 itself,
Correct.
which prescribes the duty to file the return.
10 doesn't prescribe.
11,
11 doesn't prescribe.
35.
35 prescribes.
That's
35 prescribes filing of a return by a registered dealer. Anybody who is a registered dealer has to file a return. I have filed the returns. In the returns,
you have not claimed.
some portion of input, I have claimed input tax credit also.
Not that the rate which
Some portion of input tax credit by mistake, I failed to claim in the return. I have claimed input tax credit also. That department also agrees. In fact, if your lordship see, the assessing officer passed a 39-1 order in my case, which is a reassessment. This is not a case of self-assessment, deemed assessment. It's a case of reassessment under 39. He didn't give me the credit which I missed. Therefore, I filed an application for rectification. The assessing officer rectified that mistake and gave me the credit.
what was the period when you filed the application?
The application for rectification, my lord, immediately after the assessment order, the reassessment order, my rectification application order is dated 22nd January 22nd June 2015 was my application for rectification, and the order came to be passed on 18th December 2015. Beyond period of revised return.
That will be beyond the period.
It is
Beyond
7
period of revised return.
maybe, doesn't matter.
No, that question arises.
If I have to claim it in the
If
return.
duty to claim it in the return is established.
Is established.
Not otherwise.
Yes.
Anyway, form VAT 240 is selective. Not applicable to everybody.
But it is applicable to me, and the assessing officer notes that in the form 240, I have rightly claimed it. If my lords kindly see this order at page.
But this is not the return.
It may not be written, but I have shown it in my audited financials. I have claimed it correctly, which has been audited by the chartered accountant. The input tax credit. Whether the point still remains for your lordship's consideration, if I don't claim it in the return, whether I am entitled for it still
Question.
remains.
Therefore,
But all
this is
that,
not
all
like-
that I am saying is that the assessing officer, on noting that I have made a mistake in not claiming, pursuant to an application for rectification I have made against the 39-1 order, reassessment order, he corrected that mistake in the first instance. Of course, that order came to be revised by a higher authority following centum. That's a different matter. But I'm saying in the first instance, the officer also agreed that I am entitled for this input tax return. That's all I wanted to bring to your lordship's notice. Yes. Now, my lords wanted to see the rule making power, which is section 88. Power to make rules.
Any input tax ಸಂಬಂಧಪಡದ ಯಾವ್ದಾರು ಇದೆಯಾ?
ಏನಿಲ್ಲ. General rules to prescribe.
While your lordships are at 88, your lordships may kindly see 88.4.
Any rule under this term may have effect prospectively. And when such rule is made, when specifying the reasons for making such a rule shall be laid before. And so with the rule under section 98, all rules shall subject to any modification, so and so. So that is a retrospective effect and
They have the power to
laying
make
procedure.
retrospective effect.
And laying procedure.
Laying procedure, and your lordship may see, and all rules subject to any modification made under 90 shall have effect as if enacted under this act.
Obviously.
As if enacted in this act.
So there is no question of tail wagging the dog or dog wagging the tail.
Because it will be deemed to be act itself. How this expression is interpreted by the apex court. It's there in GPC.
I'll pull it up.
As if enacted in this act.
Now, my lords may kindly see section 38, rule 38, whether rule 38 itself says that I have to claim it in the written.
I'll come to that.
Yes.
Wait. Learned Counsel draws our attention to the text of section 88, which gives rule-making power to the government. Full stop. Learned AGA specifically draws our attention to sub-rule 4, subsection 4 of section 88 to contend that the rules once promulgated and undergo the laying procedure resulting into remaining intact will have effect as if enacted in the act. First, this he says to buttress his point that the binding nature of Rule 38 should be on par with the provision of statute itself. That's what you want to say.
Now, my lords, kindly come to rule 38. Let us see whether rule 38 imposes a restriction. Itself imposes a restriction on claiming input tax credit if I don't claim it in the written. According to me, it does not. It only says what should be stated there. Rule 38, submission of monthly return. Because there has to be a specific restriction under section 10. Restriction as provided under 11, this thing. There has to be a specific restriction to deny me the input tax credit. That restriction has to be specific. That where is that specific restriction? 35 doesn't have it. Now kindly see rule 30. My lords have noted that argument. Without there being a restriction of input tax as provided under 10, there can't be any other restriction beyond what is provided, restrictions provided under 10. 10 says I'm entitled for input tax credit to deduct it from output tax credit to pay my net payable. 10 itself says what are the restrictions in claiming input tax credit, which is 11, 12, 13, 14, 18 and 19. Beyond that, if there has to be any restriction, that has to be expressly stated, which is not there in 35, which is not there in rule 38 also is my submission. Kindly see rule 38. All that rule 38 says is every registered dealer shall submit a monthly or quarterly return as the case may be, comma, containing, these are the details that that return should contain.
Please read fully.
Containing, from the beginning, my lord.
Every
registered dealer, very well. Every registered dealer shall submit a monthly or quarterly return as the case may be, containing what? Containing values of sales, purchases and other transactions, input and output tax claimed or collected, and net tax relating to all of his places of business and accompanied by proof of full payment of any tax due, including any certificate of deduction of tax at source, and a statement containing the details of purchases made within the state from other registered dealers, in respect of which he is eligible to claim deduction of input tax, and sales of taxable goods made to other registered dealers in the state, to the jurisdictional local VAT officer or VAT sub-officer in form VAT 100 within 20 days from the end of the relevant month, where the tax period is a calendar month, or 15 days after the end of the relevant quarter, where the tax period is a quarter. So according to me, all that Rule 38 says is that a registered dealer shall file a return and it has to contain so-and-so, so-and-so, so-and-so details.
ಅಲ್ಲಿ ಇನ್ಪುಟ್ ಟ್ಯಾಕ್ಸ್ ಇದೆಯಲ್ಲ,
ಇನ್ಪುಟ್ ಟ್ಯಾಕ್ಸ್ ಡೀಟೇಲ್ಸ್ ಕೊಡಬೇಕು. ಇನ್ಪುಟ್ ಟ್ಯಾಕ್ಸ್ ಡೀಟೇಲ್ಸ್ ನಿಮ್ಮ ರಿಟರ್ನ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಕೊಡಲ್ಲ ಅಂತ ಇಲ್ಲೇ ಇದೆ.
ಹಂಗೆ ಇನ್ ಸೋ ಮೆನಿ ವರ್ಡ್ಸ್ ಹಂಗೆ
It has to be there. 10 says so. Other than the restrictions under so-and-so provisions, I am entitled for input tax credit.
Learned Mr. Suryanarayana, after reading the text of Rule 38, admits that though it mentions the input tax, inter-alia deduction of input tax, comma,
Details to be furnished aste.
comma, it does not indicate that unless the input tax credit is claimed in the return itself, comma, that can be denied to the assessee.
Now that is the point. According to me, therefore, because the department's reliance is only on 35 read with Rule 38 and centum judgment. Now let's see how this very court has interpreted these provisions and dealt with centum judgment, centum infinite, and
That's Arades of judgment.
My lord?
Arades of judgment.
No.
No.
Before that, there are anyway number of judgments which have distinguished centum. I'll come to that. Now, before centum, my lord,
Which judgment considered this aspect of the matter? Only that judgment.
not in this much detail, but my lords, I'll take your lordships to the judgment. So therefore, I'll just, the issues, there are multiple issues that the department always raises. And this is only in Karnataka, across the country, nowhere else. No other state has raised these issues. It is only in the state of Karnataka that the dealers are facing this issue, only because of that centum judgment they are holding. And therefore, that judgment has been explained extensively in subsequent decisions, affirmed by the division bench, affirmed by the Supreme Court also. I'll come to that.
Show us only this much.
Yes.
Unless the claim is made in the return itself, the department is entitled to repudiate the claim for input tax.
Yes.
Or the reverse of that.
Yes.
Only that paragraph. Entire
I'll have
judgment will
to
not
take your lordships through the various judgments. That point
on
comes.
that point.
Yes, on that
Yeah.
point.
Whole of the judgment will not read.
Yeah. My lords may kindly see
Therefore,
first.
Honorable Supreme Court said, where the counsel relies upon more than one judgment, he should specify the facts of the case and the proposition of law.
Yes,
With reference to paragraph in the judgment.
correct.
And it becomes easy ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ.
Yes. Okay. My lords may first see before centum what this honorable court said about this claiming of input tax credit vis-a-vis a return. What is the petition, the SSC's right to claim an input tax credit? This is before centum, therefore there is no reference to centum here. Okay. Kindly see page 6, paragraph 5. Page 6, paragraph 5.
You are right.
The facts are not in dispute. The SSE paid 4% tax demand by the supplier in the month of June, July, and December 2005 and February 2006. When the actual tax payable was 12.5%, the supplier raised a debit note on 31/7/2006. That is after the end of the financial year. My lords may kindly note the dates and the months.
6 months thereafter.
Thereafter. It is also not in dispute that promptly the SSE has paid the difference in tax. That is, he paid the difference of tax in July 2006 after the end of the financial year. It is also not in dispute that the supplier who received the same has remitted the same to the department in July 2006. Therefore, the SSE was entitled to claim refund of input tax in July 2006. However, he has put forth the claim 6 months thereafter because time for filing the revised return also has expired. However, he has put forth the claim for 6 months. As rightly pointed out by the tribunal, if he had put forth the claim in July 2006, the amount due by the SC by way of refund was rupees so and so. Because the claim was made in December, the amount due to him is rupees so and so. Subsection 3 of section 30 deals with when and the payment of tax is to be made. It does not deal with the claim for refund of input tax. Once the tax is paid under the Act, the SSE is entitled to the benefit of input tax. Either he may retain the difference of the amount collected and appropriate it.
Where is it said he did not claim, he had not made the claim in the return?
My lord, this input tax pertained to the months of June, July, December 2005 and February 2006. The argument of it is a monthly return. My lords, let me explain the facts. It is a monthly return. So the return, the input tax pertained to months of those months, and very clearly in the returns for those months, obviously they have not claimed the input tax credit. They have claimed it subsequently in December 2000. They have paid it in July 2006 and paid it in December 2006. So in the returns for those months in which input tax credit ought to have been claimed, admittedly they did not claim. They raised a belated claim.
Go to the next judgment. We have read it now.
Just the last few lines, my lord. The delay in putting forth the claim for refund does not in any way affect his right to claim the said refund, which is legitimately due to him under the Act, and it amounts to contravention.
Therefore, they said what the tribunal has done is correct.
Correct. The entire approach of the assessing officer is contrary to law and runs counter to the spirit of the Act. That is what is important.
The
tribunal was
discussion, Mr. Suryanarayana. It does not refer to section. It does not refer to rule. Therefore,
same as
not
sentence.
say more than we have already written. It is of no use to you. Therefore, let us go to the next.
Same as centum. Now kindly come to the next judgment in Kirloskar Electric. But although this is by the learned single judge, my lord, this was subsequently considered by a division bench and affirmed by the Supreme Court. Therefore, and Kirloskar Electric,
which paragraph refers to requirement of claim being made in the return?
I'll just come to that. My lords may kindly see all this, and I'm coming to TAFE, which finally deals with that point, because TAFE refers to all these judgments. TAFE is my own case.
Okay.
SSC's own case for the earlier assessment year, identical set of facts.
This
I'm just giving the background of this dispute of input tax credit not being claimed in the return, claimed belatedly. You cannot claim it without filing a revised return. All these arguments of the government have been dealt with in multiple cases. Yes, there is a view taken in Centum and Infinite Builders, which are now pending in the Supreme Court. All these other judgments also went to the Supreme Court, which considered Centum and Infinite and affirmed by the Supreme Court, and which have been considered by TAFE, and
Which
a view has been taken.
Let us see the relevant paragraph.
Para 19, my lords have Kirloskar?
This is, yes, Kirloskar.
Kirloskar. Paragraph 19, unfortunately, page number, page is on top, page
No,
50.
Para 19, we can locate.
Yes. A closer look.
The cases, science.
This decision, in fact, covers all the decisions, my lord, on this point. A closer look at the contextual facts of the case, and as explained in bracketed portion in the aforesaid court from the division bench decision in Centum, in the light of the provisions of 10.3 and 35.4, would reveal that the claim of ITC was disallowed by the division bench not on the basis of an interpretation of the substantive provisions contained in 10.3 of the VAT Act 2003 or any restriction of period to be read therein, but because of the belated claim made by the SSE much after the lapse of the reasonable period, namely 6 months from the month of June 2006 in the month of February 2007, while referring to the belated claim beyond 6 months, the division bench referred to section 35 of the VAT Act, which prescribes 20 days period for filing the return for the month ended, and in cases of omissions or errors
Related to period of
I'll come to that. No, it is not just that. Allow me to just complete. Kindly see para 20. In the aforesaid, in the aforequoted paragraph 14 of judgment of division bench in Centum Industries so and so, however, the tribunal, they have quoted para 20, I'll skip. Then 21, I'll skip. Kindly come to para 22. This is where the substantive provision under 10.3 of the VAT Act 2003 did not lay down any such restrictive time frame for allowing the deduction of ITC against OPT in a particular tax period to determine the net tax payable for that period, and therefore there is no justification whatsoever to accept such an interpretation put forth by the learned counsels for the respondent state. Such contentions had not only been negatived, and with great respects, rightly so, by the learned single judge in Sonal Apparels, which decision also I'll just pass on. But this court is of the considered opinion that the respondent department is taking an unnecessarily distorted view of the observations made by the division bench of this court in the case of Centum, where the division bench, while
It does not relate to this.
said claim of ITC made at a belated stage and observed simply as an obiter that the claim of ITC should relate to the tax period in question. The division bench never said that the ITC invoice or sale invoice should be pertaining to the same tax period in which the credits of such
Mr.
ITC.
Surya Narayana,
Yes, sir.
it relates to limitation. It will not help you, but we will hear you till you complete.
I'll
But
just
that will not help you.
No,
We
it
assure
will-
you. We assure you, it will not help you. Go to the point where it considered non-mentioning the claim in the return is not fatal to you.
Kindly see para 23.
Otherwise, we will go on listening to you, but that we will deny relief to you. That we are making it clear.
The learned
Para
counsels.
23.
23. The learned counsels for the respondent state were at complete loss of words to the question put forth by the court as to under what authority of law the state can retain the tax paid by the selling dealer to the state as collected under the sale invoice, which is passed on to the purchasing dealer, who are the SSE's petitioners before this court. If ITC in respect of such sale invoice was to be disallowed, contrary to the very concept of VAT law and unrestricted language of 10.3 of the VAT Act 2003, and an apparent violation of Article 266 of the Constitution of India, there was simply no answer on behalf of the respondent state to this query of the court, except relying on the aforesaid obiter of the judgment of the division bench of this court in Centum. In the peculiar facts of Centum, the claim ITC credit was disallowed on the basis of belated.
One second.
Yes.
What this paragraph, according to you, mentions?
According to me, this paragraph says.
One
Yes.
second, we will understand that.
Yes.
This VAT is relatable to Article 265 in a way whatever is due, state can take. Whatever is not authorized, state cannot retain.
Correct.
This may come to your head.
Correct. That's what I'm saying. That's why I read the scheme of the act, 10.3, and that 10.3 concession, which has now become a right to me, cannot be taken away unless there is a specific provision under the act saying, if you don't claim it in the return, I won't give it to you.
But that issue is not decided
That
here.
is issue not decided.
Substantive right of the dealer is mentioned.
Is mentioned, and kindly see paragraph 25. The learned counsels for the respondent state were again without any answer to the question of the court as to how the machinery provisions of filing of the returns under section 35 of the VAT Act for assessing the tax liability, including OPT, ITC, and net tax liability under section 10 of the VAT Act can be allowed to override the substantive provisions of section 10 of the VAT Act contained in chapter 2 of the said VAT Act 2003. In the absence of any valid answer.
1 second.
Yes.
Let us understand 25.
Yes.
What 25 is saying?
25 is saying that return filing and all that is merely a machinery provision. 10, which provides for a right for input tax credit to the SSCs, is a substantive provision. A machinery provision cannot override the substantive provision. That is what 10 says, 25 says. Because like I pointed out, section 35 and rule 38 only say that I have to file a return. I have to show the details in the return, which I have done. By mistake, like for example, let me take an example, my lord. My lord, let's say I earn a salary. From that salary, tax is deducted. Or I earn fees from various clients. Tax is deducted. Now I file my income tax return by mistake. The tax which has been deducted. Now, what is the effect of tax deducted? That's the tax on my income only that he has deducted and paid it to the central government, which is akin to input tax credit. I'm just drawing a reference. Now, merely because by mistake of 10 out of 5, 5 out of 10 clients, I have not claimed it because they have not given me TDS certificate or something in the return. Can that be foregone? I mean, can that right be extinguished to me?
So
unless there is a provision saying your right is extinguished,
that is
there
absent.
has to be a provision to say your right is extinguished. You cannot claim it any further.
Unless you do like this.
Unless you do like this.
So otherwise,
it is virtually tax paid in advance. Whether it is TDS or input tax credit, what is the effect of input tax credit? My output tax minus my input tax is my net tax. So to the extent of input tax, I don't have to pay the tax because that amount of tax has already been collected by the state. Now, the tax I have paid to you, you don't want to give me credit. Is it not violative of Article 265?
in other words, your right to get back the input tax credit is a substantive right assured under the statutory provisions of the Act, and the collection and other things are matter relating to machinery, more procedural and adjective. You can't interpret those provisions to defeat your substantive right is your contention.
Correct.
Markulam. Drawing attention of paragraphs 23 and 25 of Kirloskar, Mr. Surnarayana submits that right to claim ITC is a substantive right guaranteed under section 10 of the 2003 Act, and that rules like Rule 38 being only machinery of collection, prescribing manner, mode, method, etc., cannot be interpreted to defeat the said right, said substantive right. Full stop. He hastens to add that in the absence of statute providing for denial or forfeiture, specifically, comma, the claim for ITC cannot be defeated on the ground now urged by the AGA.
Yes.
Yes.
Kindly see paragraph 26. In the absence of very valid answer and submission on behalf of the respondent state, this court can safely conclude that the machinery provisions cannot be allowed to override and defeat the substantive claim of input tax credits under 10(3), which without any restriction of the time frame allowed such deduction or credit of ITC against OPT liability of the dealer in question. And kindly see para 28. The input tax credit under VAT law is pari materia with the concept of sen-VAT or mod VAT under excise law. And dealing with a similar question, the Honorable Supreme Court in Daiichi Karkaria Limited held as follows. That paragraph I have read. Kindly come to paragraph 29. Thus, the claim of credit of input tax is indefeasible, as was the case of sen-VAT under excise law, and such credit of ITC under VAT law, which is equivalent to tax paid in the chain of sales of the same goods, cannot be denied on the anvil of machinery provisions or even provisions relating to time frame, which is law of limitation only bars the remedy rather than negativing the substantive claims under the taxing statutes. Both the question frames are therefore liable to be answered in favor of the petitioner. Now, this judgment, my lord, has been affirmed by the division bench. I'll just pass on the division bench's order and subsequently affirmed by the Supreme Court.
Kirloskar is a single judge judgment, single bench judgment affirmed by the DB in writ appeal number so and so, wide order dated. Allu reasoning idea ಅಥವಾ
Yeah, reasoning is there. I mean, extensively, everything has been quoted. Kindly turn to para 31 after noting Kirloskar and Daiichi.
ರಿಪೋರ್ಟ್ ಆಗಿಲ್ವಾ?
Idu not to our knowledge. We did not get it.
ರಿಪೋರ್ಟ್ ಆಗಿಲ್ಲ ಇದು. STRP number 234 of 2016, we had appeared for respondent.
ಇಲ್ಲ ರಿಪೋರ್ಟ್ ಆಗಿಲ್ಲ. ರಿಪೋರ್ಟ್ ಆಗಿಲ್ಲ. ಫಿನಿಶ್ ಮೋಸ್ಟ್ ಸಾಹೇಬ್ರು.
ಹೌದು.
ಇದು ಭಾರತ್ ಅರ್ತ್ ಮೂವರ್ಸ್ ಅದರ ಜೊತೆ ಇನ್ನೊಂದು ಇತ್ತಾನ?
ಇಲ್ಲ, this was a batch. It went as a batch and the lead matter became Bharat.
Lead matter is this one. In this judgment is affirmed, affirmed in STRP number 234 of 2016 between Messrs. Bharat Earth Movers Limited versus State of Karnataka, disposed of by coordinate bench on 22/12/2022. Idralli yav paragraph?
Paragraph 31. I'll not take your lordship. The discussion although starts much earlier at para 15 onwards, but kindly turn to para 31 at page 23. After noting Daiichi,
we agree with the learned single judge anta helidru avaru.
Thus, in view of the above recorded findings, we respectfully agree with the opinion of the Honorable Single Judge. The law laid down in Daiichi Karkaria has been time and again followed by the Honorable Supreme Court in several cases.
Of the DB judgment affirms views of the learned single judge.
And paragraph 32 last na tirga reiterate ಮಾಡ್ತಾರೆ division bench. Therefore, no exception can be taken to the view taken by the Honorable Single Judge that the input tax credit cannot be denied on the anvil of machinery provisions or the provisions relating to time frame. Hence, in our considered opinion, the SC shall be eligible to avail input tax credit as and when the tax is paid by them without any limitation. This has been affirmed, my lord, by the Supreme Court.
Read para 32 also. First, the DB judgment is affirmed by the apex court in SLP number
53320 of 2023.
Lordship may see over the page.
That's okay. Question of law has been left over.
The question of law, if any, which arises, is kept open to be agitated in any other appropriate case.
It's a batch of 150 cases.
Maybe.
So let me read what the Supreme Court says. Having heard the learned, the second paragraph in that.
On the
Supreme
merits
Court.
of the case.
Having heard the learned AAG on the merits of the case, we find that in the facts and circumstances of the present case, and particularly having regard to the nature of transactions involved, we are not inclined to interfere in the matter. The special leave petition is hence dismissed. Since we are dismissing the special leave petition on merits, the delay is also condoned. It is needless to say that our inclination to interfere in the matter, question of law is kept open. Actually,
What is meant by that?
what is
What is meant by this?
by the last sentence, my lord, that question of law
Correct.
is kept open? I am not sure because it goes against what is said in paragraph 2. According to, I mean, with great respect, my lord, that's what.
It says facts and circumstances. of the present.
You are more than fair.
It says facts and circumstances of the present case. And particularly
According to
having
me,
regard
para
to.
4 and para 2 go contrary to each other, but anyway,
It does not. It does not, because para 2
anyway.
clearly says facts and circumstances,
Allah,
nature of
when
transaction.
Apex Court says, it is needless to observe that having regard to the aforesaid order and our disinclination to interfere in this matter, the question of law, if any, which arises, is kept open to be agitated in any other appropriate case means, this, does it mean, we are asking you, does it mean that all those judgments do not finalize the things, we should adjudge it afresh?
The trail that goes, my lord.
Hangre ಇಷ್ಟೆಲ್ಲ judgment ಆಗಿದ್ದಕ್ಕೆ ಏನ್ ಬೆಲೆ?
Adala, that is pending separately. This only disposes of this, the Bemel batch. Everything else is pending and that is the appropriate case. This is the appropriate case. This, my lord, there either, my lord, the last line is to be taken at face value. Question of law is kept open. Either your lordships will decide, may or may not travel to the Supreme Court, or the Supreme Court will decide. That is one.
ಅಲ್ಲ kept open ಅಂದ್ರೆ the presidential value of the division bench
Precisely, my lord.
is
Everything goes.
diluted.
Everything goes.
According to me, not. I'm sorry. That is wrong.
Because
thing.
once he says.
That is not what Pune Ahmed says. Anyways, your lordships know Pune Ahmed Supreme Court.
Once, my lord, if the
What is the
argument
article?
is that this is dealt with on merits,
Constitution,
my lords, then this is the only thing that is left.
Article 141 and all that, that is a settled this thing. We don't have to. How can the observations made, the discussion go away and
Mongoose and
Supreme
Cobra.
Court has affirmed it. In what context is said question of law is kept open is not very clear, but my lords may kindly see on merits, the matter has been heard.
How courts and jurists have interpreted these observations?
No,
ಈ observations ಅನ್ನ how jurists have treated these observations in law of precedent?
we'll have to see that. We'll have to see.
According to me, this entire,
ಇದೆಲ್ಲ ಇದೊಂದು observation ಇದೆ ಅನ್ನೋದಕ್ಕೆ ಅವು ಎಲ್ಲವನ್ನೂ ಇಗ್ನೋರ್ ಮಾಡ್ರಿ ಅಂದ್ರೆ it appears to be too much. One thing. On the other hand, if we say, no, Supreme Court has made some only passing observation, and that again will be too much. Too extreme ಆಗ್ತದೆ. ಇಂಥದನ್ನ ಹೆಂಗ್ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಬೇಕು? ಮೋಸ್ಟ್ಲಿ MNVJ ಇವ್ರನ್ನೆಲ್ಲ ಕೇಳಿದ್ರೆ ಗೊತ್ತಾಗ್ಬೋದು.
I'll make my submissions, my lord, but according to me, the precedential value of these
earlier judgments,
BML judgment is lost because of this.
I'm sorry, that is a wrong statement to make. I'll come with, since I have not armed with the decisions which Pune Ahmed and
Answer
all
this.
that, I'll come with that and say, what is the effect of even SLP without saying anything being dismissed? All that.
ಅದು ಹಂಗೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಟ್ರೆ ನಮ್ಗೆ ಪ್ರಾಬ್ಲಮ್ ಇರಲಿಲ್ಲ.
Correct.
ಇದು ಹಿಂಗೆ ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ದಕ್ಕೆ ನಮ್ಗೆ ಸಮಸ್ಯೆ ಆಗೋದು.
Correct, but the presidential value will not go. And the binding value, especially on the coordinate bench, definitely will not go.
Merger agogide.
Only, in my humble opinion, only another bench of the Supreme Court is not prevented from looking into the issue.
Not High
That's
Court.
all. As far as this court is concerned,
It's final.
it is final. My learned friend can't, I mean, I'm sorry, but that's to say that BML is no longer.
In other words,
ಅದಲ್ಲ
you
ಹೇಳಕ್ಕಾಗಲ್ಲ.
have brought this question to us. We will not decide that question now. In appropriate case, we will decide it.
We will decide it.
ಹೇಳೋ
ಅಷ್ಟೇ.
ಅರ್ಥದಲ್ಲಿ
But
ಇರ್ಬೋದು.
that doesn't mean that it is not binding on
Other high
the
courts.
High Court.
Same High Court is bound by that.
Correct.
ನಿಮ್ contention.
it only leaves it open for another bench of the Supreme Court
to decide.
to take a different view if they, because they don't want to say it's not a civil appeal. If it was a civil appeal dismissed it with one line, Kunay Ahmed says that becomes the law. Even another coordinate bench of the Supreme Court cannot take a different view, only a larger bench can.
Learned AGA drawing our attention to apex court observation in the subject SLP submits that in view of that, the precedential value of the decision in Bharat Earth Movers Limited, as also Kirloskar, has withered away. First off, learned senior advocate Suryanarayana says that cannot be the meaning of the said observation. Semicolon. They only mean that in some other appropriate case, the question would be decided by the apex court, and not that the decisions of the High Court would not be binding upon the coordinate benches. ಸ್ವಲ್ಪ ಹಂಗ ಅನಿಸ್ತದೆ. ಯಾಕಂದ್ರೆ is kept open to be agitated in any other appropriate case, means to be agitated before us in any other appropriate cases ಅಂತ ಆ ರೀತಿ ಮಾಡ್ಬೋದು. Anyway, we'll see how will ಇದ್ರ ಮೇಲೆ ಸ್ವಲ್ಪ ಎಲ್ಲ ವರ್ಕ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ. ಇಲ್ಲಿ ನಿಲ್ಸಿ ಇವತ್ತು ನೋಡಿ ಆಯ್ತು. ನಾವು ಸ್ವಲ್ಪ ನೀವು ಏನೇನು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ಸ್ವಲ್ಪ ಪ್ರೊಸೆಸ್ ಮಾಡ್ತೀವಿ. ಹೌ ಏನಾರ ಅವಸರ ಮಾಡಿ ನಾವು ಮಾಡಂಗಿರಲ್ಲ. ಹಂಗೆ ಏನೋ ಒಂದ್ ಮಾಡ್ಕೊಂಡು ಒಂದ್ ಸೈಡ್ ಹೋಗ್ಕೊಂಡು ನಾವು ಮಾಡಿದ್ರೆ ನಾಳೆ ಆ ಡೀಲರ್ಸ್ಗೆ ಅನ್ಯಾಯ ಆಗ್ಬೋದು, ಗೌರ್ಮೆಂಟಿಗೆ ಅನ್ಯಾಯ ಆಗ್ಬೋದು. ಸೊ ಆಮೇಲೆ ಇದು ಇಲ್ಲಿ ಏನಾರ ಮುಗಿತ್ತು ಅಂದ್ರೆ ನೀವು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಕು. ಅದು ನಮ್ಗೆ ಎಕ್ಸ್ಟ್ರಾ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಆಡ್ ಮಾಡ್ತದೆ.
In fact, I would say, Malad, because we are concluding today and will continue on another day, I would say that if your lordships want to take a different view,
refer it to larger
it
bench.
can only be referred to a larger bench. Because Staffé itself, in my own case, it has been decided with the first judgment I cited.
But that is what the coordinate benches should have done. If they were taking a different view from centum, including Tafe.
No. ಅಲ್ಲಿ ಒಂದು ಅಂದ್ರೆ ಅಲೋಕಾರಾದೆ ಅವ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ರೂಲ್ 38 ಗೆ ರೆಫರೆನ್ಸ್ ಇಲ್ಲ. No reference is
So
made.
it was not
There
pointed out
need not
there.
be, according to you, there need not be reference because rule 38 does not have denial clause.
The department did not press rule 38 in that case.
No,
That's what
just
I'm submitting.
Assuming that whether they did not press or court did not see the rule, the judgment.
That was not discussed. Yes. Yeah, my lords
The
are right.
fact remains that it is not discussed.
Correct.
Going by your version, even if it was discussed, law would not have been different.
Not have been different. Correct. Exactly.
And it is also interesting, my lord. Single judge in Kirloskar, Madras High Court, while sitting on the division bench, says
Takes a different.
it says it is a benefit rebate concession, not a vested right. Distinguishes all cases that have.
But that's
Including his
constitutional
own judge-
validity of the provisions. That's why I pointed out the
I've got cases.
constitutional validity of a provision,
It's in a hurry.
whether you can impose a restriction, whether you can take away a restriction.
Don't worry, don't worry. Don't be-
That is what in that context to say that a concession can be given by the state, concession
Correct, correct.
can be taken away by the state. I'm not disputing that proposition.
Supreme Court has been saying so since the 60s, my lord.
But very profitable hearing so far as we are concerned. We learned so much about that. Yeah, why so much conflict and ಇಷ್ಟೆಲ್ಲ ಅಲ್ಲಿ ಒಂದು ಫೇಮಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ. Every judgment of the House of Lords makes the law more chaotic than it was before. So I think it was Julius Stone who said this. It makes law more chaotic than it was before. ಇಲ್ಲಿ ನಮ್ಗೆ ಸಿಂಪಲ್ ಆಗಿ ನೀವು ರೂಲ್ ಮಾಡುವಾಗಾದ್ರು ಅನ್ಲೆಸ್ ದಿ ಎಂತ ಕ್ರೆಡಿಟ್ ಇನ್ಪುಟ್
Tax credit is claimed in the return.
is claimed in the return, it shall not be entertained ಅನ್ಕೊಂಡು ಒಂದು ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಬರ್ಕೊಂಡಿದ್ರೆ ಇವೆಲ್ಲ ಸಮಸ್ಯೆನೇ ಇಲ್ಲ. ಇಷ್ಟು ಆರ್ಗ್ಯುಮೆಂಟ್
Because that was never the intention of the legislature. That's what the.
ಅದನ್ನ ಕ್ಲಿಯರ್ ಮಾಡಿಬಿಟ್ರೆ ಆಗಿ ಹೋಗುತ್ತೆ ಅಂತ. ನಾವು ಕೊಡ್ತೇವಿ ಕೊಡಲ್ಲ,
ಅಷ್ಟೇ.
ಹಿಂಗಿದ್ರೆ ಕೊಡ್ತೇವಿ ಹಿಂಗಿದ್ರೆ ಕೊಡಲ್ಲ. ಬರುವಾಗ ಅದನ್ನ ಸ್ವಲ್ಪ ಇದನ್ನ ಓದ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ಯಾವುದು
Precedent.
ಪ್ರೆಸಿಡೆಂಟ್ ನೋ ದಟ್ ಫೇಮಸ್ 5 judgment decision ಮಫತ್ಲಾಲ್ ನಲ್ಲಿ ರೂಲ್ಸ್ ಅನ್ನು ಫಾಲೋ ಮಾಡಬೇಕು ಅನ್ನೋ ಸೆಂಟೆನ್ಸ್ ಇದ್ದಂಗೆ ನೆನಪಿದೆ ನಂಗೆ. ಜಸ್ಟ್ ನೋಡ್ಕೊಳ್ಳಿ, ನಾವು ನೋಡ್ಕೊಂಡ್ಬರ್ತೀವಿ.
Yes.
97, 98 Supreme Court. 98
98.
Supreme Court.
Refund issue.
Refund issue.
Refund issue.
Unjust.
Correct.
Just enrichment. by-
Correct. That one.
Which day your lordships are fixing it?
Nade.
My lord, tomorrow I am in Dharwad. Can it be Wednesday, my lord? Next Wednesday. Thursday.
If you are citing multiple judgments, you also.
As your lordship said, the
ಆ ರೀತಿ
ratio,
ಮಾಡಿ.
the facts ratio and.
Facts, ratio, paragraph. You can have one more column. Your comment on that.
Yes.
ಆ ರೀತಿ.
Eventually, my lord, I'll be able to distinguish Daichi and the mischief it is causing.
ಒಂದ್ ಸ್ವಲ್ಪ ಹೊತ್ತು ಕೂತ್ಕೊಂಡು ನೋಡ್ಕೊಂಡು ಮಾಡಿ ಮುಗಿಸ್ಬಿಟ್ರು.
Eventually, I'll be able to distinguish Daichi and the mischief that it is causing.
Let us see. Okay. But you have to overcome whether substantive provisions of law, what they give benefit to the citizen, can they be taken away by machinery provisions?
Somebody is.
Because of paragraph 23, 24, 26, which he has written. ಅದನ್ನು ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಬನ್ನಿ. All.
Grateful.
Further. Thank you.
Grateful.
ಇದೆಯಾ? ಸರಿ. ನಾವಿನ್ನು 2 ರಿಸರ್ವ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಇದು ಮಾಡ್ಬೇಕು, ರೆಡಿ ಮಾಡ್ಬೇಕು. ಅವ್ರದ್ದು ಇರುವಂತದ್ದು.
My lord, this matter will also take some time. It was an interesting discussion. I was also learning all the way. Would my lord keep it on another day or we can go on? I have no issues either way.
No issue. Whichever date you want, Mr. Rao sir.
My lords, I leave it to my lords because it is the end of the day.
This is transfer pricing, my lord. Many matters have been admitted on the same issue.
No, that is, my lords, may I make one request? That is why I didn't want to join issue. Transfer pricing is not a ghost. It is part of the Income Tax Act. Principles for deciding whether a substantial question of law. Please allow me to complete, sir. Or you say I will wait. You complete, sir. I will wait.
Anyway, we'll have it after 2 weeks. Wait. Call this matter after 2 weeks.
Obliged to my lords. My lords will have to someday give me some opportunity. I will try to convince my lords. Otherwise, I'll learn and go. I have no problems.
No issue.
I'm not saying I'm right, but I have I want to say something and try to convince my lord.
Very well. Very well.
Any convenient day, kindly give me some time.
All right. After 2 weeks, you can have any day.
Very well, my lord. After 2 weeks, kindly get it listed. I will assist the court.
Okay.
Obliged to my lords.
Are you from Bangalore?
My lords, I am not from Bangalore, but I am almost a resident of Bangalore because I have do so many cases, but I reside in Delhi.
You are in Delhi.
But on the day my lords will fix, I will be personally present if necessary to assist the court if that is more convenient for the hearing.
No, we can't assure that because.
Okay. Then I'll kindly permit me to join on virtually only.
All right.
Obliged to my lords.
Next. 2 weeks. Yes, Tanmay.
31, my lords, I find a VSV application, my lords, can be taken up 2 weeks.
Call up 2 weeks at the request of assessee.
Appearing for petitioner.
That's for the respondent.
As now
ಮಾಡಿದ್ರಿ ಅದರಲ್ಲಿ
ಇವನ್ ಈ ಸೆಷನ್ ಅಲ್ಲಿ ಹೇಗೆ ನಾಲೆಜ್ ಬಂತು ತುಂಬಾ ನಾಲೆಜ್ ಇತ್ತು ಅದೇ ರೀತಿ ನಮ್ಮ ಮೀಡಿಯೇಷನ್ ಕೂಡ ಫ್ರೂಟ್ಫುಲ್ ಆಗಿದೆ ನಾನು. Yes, and we have arrived to a decision to buy back the apartments, and which majority of the owners has agreed. And again, 2 weeks may be needed, and we have assured
some direction, since as mediator, I'm bound by confidentiality not to place the discussions. But there is some direction. There appears to be 2 buckets of solutions. A little bit of effort has to be put in by both the sides in implementing those. If they're able to put in that little bit of effort, concretize the 2 buckets, then we'll be able to file a report along with certain agreements.
Time ಬೇಕು. Learned mediator, Mr. Aditya Vikram Bhatt, submits that the talks are going in a fruitful way. If both the sides walk extra mile, amicable settlement can be arrived at. First up, both the sides broadly agree with this proposition. First up, in view of the above, call this matter on.
maybe on 4th of March.
ಇಲ್ಲ ಅವ್ರಿಗೆ ಕೇಳ ಮೀಡಿಯೇಟರ್ ಇದ್ದಾಗ ಅಲ್ಲಿ ಮೀಡಿಯೇಟರ್ ಮಾಡಿದೆವು ಅಮಿಕಸ್ ಮಾಡಿದೆವು
Mediator.
I'm okay with 4th of March.
4th of March. ನಿಮ್ಗೆ ಫೀ ಎಲ್ಲ ಕೊಟ್ಟಾರ? ಫೀ ಪೇಮೆಂಟ್ ಮಾಡಿದಾರ?
Please. Yes. Okay, please.
ಇಲ್ಲ ಹಾಕಿ ನೋಡ ಹತ್ಲ ಬರ್ತದೆ ಅಷ್ಟೇ. 4th of March ಬದಲಿ ಫ್ರೈಡೆ ಹಾಕೊಳ್ಳಿ. 7th of March ಹಾಕೋಣ. Okay. Suppose for any reason, if some change, etc.
Not on 7th.
No, it has to be on 7th only. It cannot be any other day. For some reason, we can't tell it to you. Yes.
Pleasure. Much.
The serial number 35. 36, sir, sorry, 36. 4 weeks. The Passover, ಇದು adjournment mention ಮಾಡಿದ್ರ ಅದನ್ನ? ಹಾ.
Title ಮೇಲೆ ಏನೋ discount out of the title.